A good morning, ladies and gentlemen. Once again, a good morning, ladies and gentlemen. Welcome back for this second day of the National Alternative Dispute Resolution Summit 2023. It's a pleasure to see all of you, and we are starting right now. Just like we did yesterday, in the spirit of the motto of this country, for God and my country, I would like to welcome one of us to lead us in an opening prayer as we start our day, so that the Creator of the universe will guide us through this whole day. And let me right now welcome Madam Patience Wichire, the Head of Legal and Advisory Services at the Uganda Registration Services Bureau. Council Patience, kindly come and lead us in an opening prayer. Let's make her feel at home by welcoming her with a round of applause. Welcome, Patience.
Thank you. Let's stand on our feet and pray. God Almighty, we bless you for this morning. We want to honor you for yesterday, for the fruitful discussions and the launch that we had. We thank you for this national summit, the first one of its kind. We thank you that everything went according to plan yesterday. And Holy Spirit, we invite you this morning as we begin our day too. We ask that you will come and preside over this day, that we'll have fruitful discussions, that our sessions will go well, that they will be meaningful for us, that we'll make meaningful contributions, and that above all, your presence, your spirit will be with us, and we'll have a fruitful day. We thank you for everybody that is here present with us. We pray and thank you for the organizers. We pray for those that haven't joined us, that Lord, you will quicken their steps and they will get here and join us in time. We honor you and give you the rest of today. In Jesus' name we believe and pray. Amen.
Amen. Thank you very much, Council Patience K. Wichire, Head Legal and Advisory Services, Uganda Registration Service Bureau. So once again, I welcome you, ladies and gentlemen. I haven't changed. I'm Samuel A. Bakutana, certified executive coach, award-winning leadership consultant, a global speaker and author, 17 books in the areas of leadership, business, education, and relationships. I am the CEO of Inspired Leaders International, an international leadership development firm that empowers leaders to transform institutions and nations. Doing that, I've been able to do a lot of work as a leadership consultant, as a certified executive coach with the Parliament of Uganda, Parliament of Kenya, National Youth Council of Rwanda, ANC Nigeria, Microlabs in India, Columbia University, Government of Japan, Government of Netherlands, United States Agency for International Development, and currently I'm one of the 12 executive coaches under the Kofi Annan Global Health Leadership Program, coaching permanent secretary level leaders in 38 African countries. So it's a joy to be here this morning to be leading us through this program. Greetings from my dear wife, Charity, who sent you her love and greetings this morning. She told me she was online watching everything that was going on, and the energy you see me with this morning is because she gave me a high five and said, "You made me proud." All right. So our program as it is today is just like we talked about it briefly yesterday evening when we were rounding up the whole day. We are going to get into two different tracks. We will have a track of the judges, and the judges, you're going to be in Choga Hall, just down here on the ground floor, Choga. And then the practitioners and users, track 2, you are going to stay in this room. And we are going to be having different people leading the training faculty. Concerning the judges, we are going to be looking at a brief introduction to ADR as it relates to the global emerging trends. And Professor Jack Ko from Pepperdine University will be leading the conversation. As for the practitioners and users, you will be looking at ADR following the wave of international acceptance and understanding the potential of ADR in this country, in Uganda. And Professor Selina, who is right there, is going to be leading the conversation. So without further ado, let me request us to now transition to the different tracks. The day is packed with a lot of awesome stuff. We will be launching the alternative justice system strategy today, and also we will be launching the summit website where we can go and get all the details of the documents, the presentations, the remarks, and so on and so forth that have been presented in this first high-level national Alternative Dispute Resolution Summit 2023. Ladies and gentlemen, may I now take the honor to request the judges to humbly transition to Choga Hall now. The Honorable Minister of Justice and Constitutional Affairs is asking that how about the traditional judges like him? As long as you are a judge, traditional or non-traditional, feel free to find a good comfort in Choga Hall. And then the practitioners and users, you are free to stay in this place. We will take about 1 hour, be back at about 10 a.m. for the next session. Once your session is done at about 10 a.m., you will immediately transition to break time, and we will be back into the room at 10:30 a.m. to continue the sessions. So 10:30, we will be coming out of the break time. From the track conversations, at 10 a.m. continue for the break, and then at 10:30, we will be back for the next session. Remember, conflict is inevitable, but combat is optional. Let's use ADR. I will right now welcome Professor Selina to kindly take on the next session that we have in this place for the practitioners and users. May you please make Professor Selina feel the warmth of Uganda, the power of Africa, the one and only nation that is beautiful in and out, gifted by nature for God and my country.
There we go. It is great to see everyone back today, and welcome. I want to first introduce, I'm not going to be teaching today by myself. I have half of the cohort who has been doing the MDR at Pepperdine, who will be training with me and helping me throughout the day and sharing their experiences. And I hope that we can agree that we have mediation confidentiality in this room, because just between us, I think I got the really fun group of the cohort. So don't tell the other track, but I think you're going to have a good time today. Helping me out today will be the Minister Mao, and he talked about the Tom Sawyer moment, but I think we'll be good. Minister Mao joined the group a little bit late, and it's been so great getting to know him here. We're going to talk today about mediator rapport, building rapport, and I think Minister Mao has that trick down. Then I would like to also introduce you. We're going to be having as part of the cohort Justice Kira Weirby. He is going to be working with us, and we saw his book launch yesterday, and we were so grateful. He took us on a beautiful tour of the bookstore, Aristoc, the other day, and just showed us great hospitality. Also took us to the appellate court, and we're excited to be working with him. And then we have my dear friend, the Solicitor General, Francis Otoke. I met Francis, I think it was 2018 when I met Francis, and the cohort teases the Solicitor General about being always the A+ student, because he always has the best questions and delves deep into the work, and so it will be a pleasure to have him working with us today. And then we have Madam Rachel Ado. Where is Rachel? Back there. Rachel's going to be helping us out today. Rachel has a natural mediator's presence. I've been watching Rachel. I met Rachel for the first time, I think in 2018, and she just has that natural, calm presence. I don't know if you saw that yesterday when she was facilitating the group up here, but she just has this beautiful calm about her, and also a great listener. When she speaks, it's usually profound, but she's always listening, which is such a great mediator trait. And then we have, I'm looking for our last cohort member. It's Senior Counsel Francis Gamera. Where are you, Francis? I don't see you. Well, he will be here if I don't see him, but I will tell you, those of you, I'm sure all of you know Francis, his mediator trait that I see so much of, he always has a great attitude, and that is such a big piece of being a mediator, is having that positive attitude, and Francis always brings that to the track. So they will be helping us in the later session. So can we give them a round of applause and a welcome? So I've had this kind of 7-year love affair with Uganda. I came into a group of 50 judges from all levels, and I have to say it was an experience. I was humbled and honored, and had to go to Pepperdine and teach 2 other groups. You probably, when President Jim Gash was inaugurated. And these last few months, and you know, as a professor, you don't get the experience where your students take the information for their country and then put on a beautiful, beautiful pleasure. Before I tell the group anything about myself, I always want to find out in good mediator fashion more about you. And I understand that you're the practitioners and the end users of mediation, but I want to know, from a show of hands, how many of you have had a basic mediation training? Can you show me by your hands how many of you have been trained as mediators? Okay, so not a lot. Okay. How many of you have been in a mediation? More. Okay. Okay, go ahead. If you've been in a mediation, keep your hands up because I'm going to give you numbers. So, more than 5 mediations? More than 10 mediations? Okay. More than 20? Okay, more than 50? Okay, so we have a couple practitioners who spend a lot of times in mediation, and then quite a few of you who haven't even been trained in mediation or have not been in a mediation. So today we are going to delve in to kind of exploring and talking about best practices, but I wanted to understand a little bit more about your experiences. So let me tell you just a little bit about me. Whoops. I run a place I'm not in California. I'm actually an adjunct professor. So I travel to Pepperdine when I teach, or I teach online. So I got smart. I live in a place called Pittsburgh, Pennsylvania. So it's a colder place in the winter. So I finally got smart, and now I go to Malibu to teach in California in January and February. But most of the time, you'll find me at this place called the Conflict Lab. And the Conflict Lab is a place where our mission really is to get organizations and individuals to do conflict better. And I started out life as a mediator, and that grew over time. And what I decided is it didn't belong in a law firm. The work that I was doing was something different, something more sacred. And I really do consider mediation and dispute resolution work sacred. And I had a question at lunch yesterday from the minister. He said, I want to know your story of why dispute resolution is so important to you and why you're so passionate about it. And why I'm so passionate about it is people get stuck in conflict. We all do it in our own lives. People do it in cases. Organizations get stuck. And there's something magical about mediation that we're going to talk about today. Something that happens where people can get unstuck because they connect with their inner wisdom. They connect with what's really important to them. I call that the real, and it's something about this process. And so people are able to move forward and let go what happened in the past. In litigation, we often spend our time talking about what happened in the past, who did what, who's to blame. But in conflict resolution, we might not be able to agree about what happened in the past, but we can agree about a path going forward. And that's why this work is so sacred. And when I built the Conflict Lab and gave it a sacred space, bigger things started to happen. And I really thought about, what do people need when they're stressed and they're coming to talk about conflict? The inside of the Conflict Lab looks very different than a law firm. Here is where we do our opening statements. And I don't tell people where to sit. And it's always interesting to see where people sit. But people can be comfortable. And if you think about when a mediator does their opening statement, you don't need a table in front of you. We're sitting down to have an informal conversation. At the lab, we do all kinds of conflict facilitation work with groups and individuals. So here's some pictures of that work going on. And you can see it almost has more of the feeling of a home. This is the space upstairs where we do smaller, more intimate mediations. So mediations between couples or an employee and a manager or two business partners. I'm working right now with two law firm partners who are having some trouble. I don't know if any of you can relate to maybe having trouble with your law firm partner, but this is a spot where we do those types of mediations. Around the lab, there are lots of signs to get people thinking about the value of conflict and how to do it differently. This is one of the signs. My daughter, who's an artist, I get her to do things for me. So she painted this quote on the wall, and this is from a very famous woman named Mary Parker Follett. If any of you have studied management, you probably have heard her name. She's called the mother of modern management, but I like to call her the mother of modern mediation. This quote, "All polishing is done with friction." Getting people to think about conflict isn't all bad. We usually have to go through some conflict to have some creativity, some new things happen, growth. Here's another piece of art that's in the lab. We have a lot of art from a mediator who's an artist named Brad Heckman. He runs the New York Peace Institute, and he has these beautiful drawings and paintings that he does with quotes regarding conflict. We also have a dog. We have a mascot in the lab. She's a French bulldog, and her name is Conflit, which is conflict in French, and we call her Flea. And just as a side story, just thinking about how people are coming into this space and feeling very different than they do in a law firm. This is one of the clients we had one day. And so I was doing an estate case with two brothers, older brothers. They were in their 60s, but their parents had passed away, and their parents had been very wealthy. So these two brothers had never really had to work much, and now their parents had died, and their estate was running out, so they were fighting about the money in the estate, and they'd come to me to mediate the dispute. And they had each come in for meetings, pre-mediation meetings, which we're going to talk about in a moment, and they'd seen the dog. And the one brother who was flying in from Florida, he asked if he could bring his dog. This was his dog, Lucy. "Can I bring Lucy to the mediation?" "Sure, bring the dog." So we went through the mediation. The dog sat in the middle of those two white chairs that you saw in the first picture. And we broke up in rooms, and the one brother and the dog stayed downstairs, the other brother was upstairs, went back and forth, and finally these brothers who had been fighting for about 5 years came to a resolution about what was going to happen. But here was the thing, is while I was doing the paperwork, the brother who was upstairs, who had not brought the dog, he goes, "Is there a way that you could bring the dog? Could you ask my brother if Lucy could come up here?" I thought that was a strange request to bring his brother's dog upstairs, but I said, "Sure, I'll ask him." So I went downstairs and I asked, "Can I bring Lucy upstairs? Your brother wants to see Lucy." And he said, "Sure." So I took Lucy upstairs. And the brother upstairs then told me, "I haven't seen Lucy since Mom died." Lucy was the mom's dog. So it was clear that there was something magical about having the dog there that day. I'm sure that having the mother's dog there while we're having all these conversations kept these people in a different frame of mind. And that's some magic of mediation. I want to tell you then about yesterday. I tried to be a good mediator and listen to all of you and hear both the concerns of the practitioners, and then I also heard a lot of enthusiasm from the users, from the banks who would like to be using mediation. And so my talk today, I'm going to try and address some of those concerns and also talk about what the potential is here in Uganda. And one of the things that's been pretty magical and that I feel so grateful to God about my career has been the ability to go mediate in all different types of places, states, countries. And the one thing that I've figured out is although culture can divide us and we can see external differences, when it comes to patterns of conflict, they're pretty similar. I did a big mediation last year with representatives from 27 countries. So there were a lot of cultural differences, but how they were thinking about conflict and what was upsetting to them and what they needed was the same. And so I want to tell you this. I also think that the wave of acceptance of mediation does the same. It has a wave of acceptance that's pretty predictable and that I've seen happen over and over again, whether it is a state that is in the US coming up to speed on mediation, or if it's a country, or if it's a certain section of the court that is developing mediation. There seems to be a pretty predictable pattern. So I want to share that with you because I think it might give you some kind of comfort and a guide of where you are. And I didn't pick the wave because Pepperdine's mascot, I don't know if you know it, is a wave because it's right by the beach. That's not why I picked it. It's because years ago, when mediation was just taking off in my state of Pennsylvania, a pretty famous mediator from California told me to be patient. He said, "Be patient, Selena. It's a wave. It's a wave of acceptance." And I can see from Uganda, from coming here in 2016 to even now, you've moved forward on the wave. So this is what usually happens, is that there are some kind of community mediation processes already in place, because I want to say that I think it is just human nature that we know that individuals should be responsible for their own disputes. The next step of the wave then is it gets mandatorily put in court. So court kind of takes the reins and says, we're going to do this. And they figure out, and I've seen different courts do it in different ways. Sometimes they have judges as mediators, as your court has done. Other times, courts have trained up attorneys to be the mediators, but they put in some type of mandatory mediation. So that's the next step of the wave. Then what happens is you usually get what I heard some talk of yesterday is pushback from the bar. And the bar, it's pretty a normal feeling, right? You are stepping on the work that you're doing. And so there's concern about the fact that it's going to take away business. There's concern about the fact that your clients aren't going to get the justice that they deserve or in the way that they should. And there's just resistance to change because it's something very different, and you've been trained in a certain way to help your clients in a certain way, and it's a new process that it's unclear what it's going to look like. But then you have what we saw up here yesterday. You have the end users, so we saw that yesterday by our bank representative, get really excited about it because they understand that mediation could resolve their disputes faster. And then we heard the gentleman, the senior counsel from Kenya yesterday, when he was very blunt about clients' views on their conflicts. And I'll just say I had a dear mediator friend who used to put it this way. He said, clients don't come into our offices wanting to purchase a complaint, a deposition, 2 discovery requests, and a trial. That is not what they're doing. That's not in their headspace. That's not what they're coming to purchase from us. What they're coming to purchase from us is resolution to their conflict. They want an end to whatever pain, whatever hardship, they want a resolution. And they want as quickly as possible and as inexpensively as possible. And that's really what our clients want. And so that's why you start to see when the end users start to understand that there's this other vehicle out there that's been successful other places, they start to push. So you have the courts mandatory, the end users pushing. And what I've seen then eventually happen is eventually the attorneys slowly start to grudgingly get involved in mediation. But what I've found is the most sophisticated attorneys, I think in my own experience in my own state, and I've seen it over and over again, they start to understand that it is still practicing. And it actually is a more creative way of practicing because you get to really problem solve in a different way than you do in court. You have a lot more control. You get to pick your neutral. You get to pick the time. You get to decide, when are we going to do this? Are we going to do it pre-suit? Are we going to do it once discovery's done? Are we going to do it right before court? So you have a lot of control. You still have to represent your clients, and it's a different relationship that I see attorneys who have grasped the mediation process start to have with their clients, because they're in problem-solving mode instead of, you watch me, I'm going to defend you. So it's a different relationship. There's also a relationship, a different kind of mediation advocacy, and we train it, and other universities train it now, that happens. So what ends up happening, the final part of the wave, is when it feels good to the attorneys. And I'll tell you, because now in the US, it is the predominant mode, not arbitration, mediation. It's the predominant mode of dispute resolution. So much so that the American Bar Association in 2017 changed the name of their committee, the Dispute Resolution Committee, the Alternative Dispute Resolution Committee. They dropped the alternative. They said that doesn't make any sense. The majority of cases are getting resolved through mediation. It's not the alternative anymore. So that just shows how predominant. So let me tell you, the federal court, when it was in 1998, when they required every district court to put in a program of ADR, a pilot program. And so I'll just talk specifically first about the Western District of Pennsylvania, where I live. They put in 3 modes of ADR that everyone in a civil case had to choose from before they could see a judge. You could do arbitration, you could do mediation, or you could do something called early neutral evaluation, which may be what you consider your conciliation, where you would hire somebody who's an expert in substance, and they would hear both sides and then almost give a preliminary ruling of what they think would happen in court, and then both sides would talk through. The people who were doing the arbitrations, the mediations, and the early neutral evaluations were practitioners who were trained in those areas. And really that's all the court required, is to get on the panel. You have to have a certain type of training, and they had very specific criteria for what that training looked like. And you did an application to the court, and then you were put on the panel. Then, when I go to court, I get an order for ADR, and I have to choose with the other counsel which one we're going to do, and we get to pick anybody on that list. So it's really up to us to get to pick. So I will tell you, currently, all these years later, what has happened is about 1% does arbitration, because it's really private court. It takes long and it can be expensive. So really only 1% use that. About 5% use early neutral evaluation. And I want to be really clear, the Mediation Council that I'm a part of, we really lobbied for that early neutral evaluation because we wanted to be really clear. It is completely fine to get an evaluation of your case to help you settle. But read my lips. That is not mediation. That is something different. You can use mediation skills there, but that is not mediation. So we wanted that to be separate. So about 5% of people use that type of mediation or of ADR. The majority of cases are mediation. And now in our federal courts in Pennsylvania, less than 1% of cases are tried. 1%. So 99% of cases are resolved through ADR. And the statistics go a little bit up and down across the country, but in general, 98% of cases are resolved in that ADR process. And I'll tell you, as the attorneys, what we found is clients are happier. They're more satisfied. So the fear of we're going to lose clients, we're not going to have clients, that's not the case. They feel satisfied with the result because they were part of it. They're part of the work. They're much more, as Justice Kaye talked about yesterday, they're much more in power now of their dispute, and that feels good because litigation is super stressful to litigants. So what we found, and from talking to attorneys, those fears that they had that their cases or their revenues were going to go down, no, they have more clients. And especially in Uganda, when I heard yesterday the number of disputes that don't even come to litigation, you have a rich opportunity for many more people to be coming to court and using ADR methods to resolve their disputes. So there's the wave, and I want to talk a little bit too about thinking about ADR and particularly mediation in bigger and larger ways. And one of the things to think about is pre-suit mediation. So things that aren't in litigation yet. So workplace is a huge area for mediation and a huge opportunity for you to have clients who don't ever intend to go to litigation. So companies are starting to become well aware that when they have disputes between a manager and an employee, they can call in a mediator and have a mediator help them resolve their conflict without ever having to file anything in court. So I want to open your mind to that's a way that you can be helpful. A lot of large companies in the US and across the world have started putting in pre-suit mediation programs to deal with both employee disputes, but then also to deal with consumer disputes. A lot of private mediators will be on panels for companies who have consumer mediation. So one of the panels that I'm on is for Home Depot, which is a big box store, as we call them in the US, that is a hardware store. And so when you go in and to the garden area and you want to buy some plants for your garden, and there's water on the floor, and you slip and fall and hurt yourself, Home Depot will contact you before you file a suit and see if you would be interested in doing a mediation. And these mediations are incredibly successful. Lawyers of the plaintiffs appreciate them because they can get their clients taken care of faster. The company saves millions and millions of dollars by doing this, even when they do nice payouts to plaintiffs, because they're not going through the litigation experience, they're not clogged up in court, and it makes customers come back to the store. They feel like they were treated with respect and swiftly instead of being in a long legal battle. Because really, why do companies want to be in a legal battle with their customers? There's an organization called FINRA that deals with conflict between brokers and their clients when they have disputes. And those are mediators who any mediator can apply to do that work. So a lot of these organizations have panels for private mediators. And so many mediators who work full-time are on a lot of different types of panels. So I want to pause there and just wrap your head around the idea and the possibility that mediation is a separate practice. It is a separate practice from your legal practice. It is a separate skill set, and there's lots of mediators who are not lawyers. Definitely your lawyer background is going to be helpful to you, but we also see many mediators who are not lawyers. And even now, the American Bar Association, in their dispute resolution committee, they allow in non-lawyers because it's a distinct skill set. And I heard someone, I can't remember now who, I think it might have been the head of the commercial court yesterday, was talking about maybe the best mediator isn't the one with the best substantive knowledge, but the one with the highest, I think they said, ethics. But really, if it's with the highest skill set. Mediation is a very distinct set of skills to be able to step into a conflict, understand it, identify the interests, and be able to help facilitate decision-making of what to do next. It's not evaluating a case. That's not what a mediator does. A mediator asks questions to help the parties evaluate their own case. So I'll tell you, when I practiced for 3 years, I practiced family law. I now mediate employment cases. I go to Chicago and mediate personal injury cases. I never practiced personal injury law. I never knew anything about law in Chicago, Illinois. I don't still really know too much, except when I'm in the mediation. I help parties think through based on what they both know about the law. And I do bankruptcy law, and I'll get pulled in sometimes on banking cases. I do real estate cases because people know I'm a good mediator. So I want to expand your idea that a mediator is somebody with substantive knowledge. And there are many professional organizations across the world for mediators specifically, and they don't talk about whether or not you're a lawyer or not. It's a different skill set. Mediation's also used in a lot of ways, and I want to share this with you. There's an organization called Mediators Beyond Borders, and these are some pretty important people who got the chance to have at the lab. They started Mediators Beyond Borders, and on the left there is Ken Cloak. Ken Cloak is a professor at Pepperdine, but he's also a world-renowned mediator, and he's written 12 books on conflict, and he's just a brilliant, brilliant man. And he was thinking one day, why do we drop bombs when there's areas of war? Why do we do that as the US? He said, we really should be dropping in mediators. We should be dropping in people who can help resolve disputes. So this was his vision. He started it with the other gentleman in the photo, whose name is Bob Creo, and they started this organization called Mediators Beyond Borders. It actually started in Pittsburgh, where I live. Now this organization has grown incredibly. Prabha Sakarana-Ryan, who is in the photo, is the CEO of Mediators Beyond Borders, and in November, they have a congress, a peace-building congress every year. This year it's going to be in Kenya in November, so you might want to think about going. But they go around the world training mediators, especially women. They found women in areas that have been disrupted by conflict. It's usually the women that are starting to pull together the community and the stability again. And so they have gone to countless areas all across the world now. And they're very connected with Rotary. I know some people in here are connected with Rotary as well. But they do amazing work. And these are really mediators who are working with refugees, working in peace-building efforts. The other thing is that there can be mediators in community centers. There's community centers across the world for mediators, really where people go in and train the local people on how to be mediators so they can mediate disputes between neighbors, small claims disputes. They can even do family mediation. And during COVID in the US, there was a huge eviction crisis. And for a while, there was a moratorium on collecting rent. But we knew once that moratorium was lifted, people were going to be in big trouble. And so to try and get ahead of that, at the Conflict Lab, we started a community mediation center that was dedicated at this point to deal with evictions. And to this date, we have resolved 1,000 eviction mediations. So that means 1,000 people are stable in their homes that wouldn't have been. And how we did that is we trained 75 people from the communities we knew were going to be hardest hit. So we didn't go in and do it. We trained people in the neighborhoods that were going to be hardest hit by eviction, so they were given the tools to respond and deal with the issues they had. This last year, these last few years, I want you to think about mediation being used to deal with crises in communities. So if you develop these skills, you can be used in so many different ways than just in a litigated case. In Pittsburgh in 2018, there was a shooting at the Tree of Life Synagogue where 3 congregations were actually praying a Saturday morning. It was Shabbat. And an armed gunman with an automatic weapon. I know you hear about our terrible mass shootings that we have in the US. But this one was particularly bad in the sense it was a hate crime, a very specific hate crime against Jews. And he went in and hunted down 11 deer victims who are really they were the people who were there early. They were the people who let everyone in, who handed out the prayer books, who made sure everything was ready for services. He gunned them down and hunted them down. There was a resiliency center. The U.S. has started putting together resiliency centers when there are these types of mass shootings. The Department of Justice actually pays for them. The Resiliency Center contacted me and said, we would like you to come in and mediate this group of families of the victims and also the 3 congregations to figure out how they're going to memorialize their loved ones. It sounded hard, but I had no idea how hard it was going to be because when I got in there, they told me a little bit more. The 3 congregations had huge conflict because, as you can imagine, across the world news, it always said Tree of Life. You never heard about Dor Hadash and New Light, who were also renters in the synagogue. And so where did the money come in? It went to Tree of Life, right? It went to Tree of Life. There were so many other issues that had happened between the 3 congregations and how things were done in the news. And so there was so much conflict in this community. So it wasn't simply just doing a memorial, it was helping this community heal. So mediation skills can be used to help work with communities that have been covered with conflict or trauma. I also want to point out that there's some really good mediation offices across the world that you can start to look to as you figure out how are we going to try and coordinate all the mediation efforts in Uganda. And one of the best ones I know is an office in Maryland called the Mediation and Conflict Resolution Office, and it's called MACRO. They coordinate all of the mediation efforts in that state. And they do an amazing job. And they do all types. They coordinate all types of mediations. And they really, their goal is just to make sure that mediation is done well, mediators are trained, they're a resource, they have a community mediation center, but they are really the gold standard. They also do a lot of research. So they really help us understand what works well, what doesn't work well, and they are the gold standard, I would say, at looking at a mediation office. I want to just talk now then why Uganda is really well placed to embrace mediation and be a leader in mediation. And it has everything to do with who you are. And I speak very sincerely. There was lots of conversations yesterday and in the questions we received preparing for this conference about the fact that as a country, you had many dispute resolution processes in villages before colonization. So there's that rich history. But I want to say there's something else, and you're probably not even aware because sometimes you're not self-aware of how special you are. But the hugest part of mediation is the recognition that people want to be seen and understood. And that is part of you and your fiber and who you are as a country and a culture. And yesterday was such a great example of that. The way everyone has to be recognized and mentioned and taken care of and given respect. That deep respect for people, that is what you're doing in mediation. The fact that you acknowledge people where they are. And I can give you the example of dealing with dear Andrew Hauka, who you all know. I will call Andrew and I will try and jump right into what we need to talk about. And he'll say, "My sister, how are you?" And he will ask me questions and want to know about my family, and he will meet me at a human level. And that is what at the core of mediation. It is meeting people at a human level. And I really just, after my 7 years of being around Ugandans, I just think that that is something that is so innate in all of you. And I don't think you probably realize it, but trying to drop away that formalness of court and the court process and going back to, I look at in mediation, as I said in the beginning, why it's so special to me is because we're getting people back to their inner wisdom, that best part of themselves, that place where they're at their real, and they're gonna make decisions based off of the best part of themselves. And what I think the big opportunity is for Uganda is once you get some of these structures in place to help you, so some standards. I heard a lot yesterday about the concern about if there's not a court case, it's hard to have a mediation agreement that is recognized and is enforceable. And we're going to talk about that a little bit later. But once you get those things out of the way, those are just process things. You can get those out of the way, and you definitely have some smart folks working on that, and the new policy is going to try and address those things. But at the core, really, if you get back to that inner wisdom of the country of we treat people with respect, we give people in the disputes the power to resolve your own disputes, you're going to take off. You're going to take off. And there was mention yesterday by Justice Kira Weirby about the fact that you really do need to get strong on your domestic and internal mediations before you go international. I really do believe that's true. It's starting with the basics and getting really good, and that shouldn't be hard. But getting that done, and then internationally, I cannot imagine that you will not have great success as mediators on the international front. I think about, I'll just, we'll see how we're doing on time. I'm good, very good on time. I'll just end on this. My daughter, who is in med school, told me something that I know my kids, let me just tell you, my kids tell me that every time they tell me a story, I somehow relate it back to mediation. But that's how my brain works. But my daughter, who, when she was in med school, before she was a doctor, she told me about the fact that if you take 2 heart cells and you put them in a petri dish, something really cool happens. Because I don't know if you know this, I didn't know this, but heart cells beat. When you take 1 heart cell, it beats like a heart. When you put 2 heart cells from 2 different people inside a petri dish, within a few minutes, they start beating together. Isn't that amazing? And that really is the core of mediation. When people sit down to resolve their disputes, they're given a container and a process to elevate their thinking. That's what happens. So with that, I will leave you to tea, and we'll come back a little bit after 10:30, and the cohort will join me, and we'll start moving through some of the magic and the best practices of mediation. Thank you.
Ladies and gentlemen, you will agree with me that Professor Serena is not only an expert, but also somebody whom you don't want to see stopping to speak, because as she speaks, a lot of wisdom is coming through, a lot of personal experiences, stories of transformation, showing the how in a voice that actually encourages mediation. Let's appreciate Professor Serena for taking us through this session. Thank you very much. We are better than when you started speaking. So let's take off some 30 minutes of a break, a healthy break. Grab some coffee, grab some tea, relax, stretch, be happy. And at 10:30, be back for the next session. See you then. Ladies and gentlemen, good morning once again. I am used to people responding whenever I greet them, but I realize it's a different environment. So I will just make one more attempt. If I'm successful, I thank God. If I'm not, I simply move on. Good morning once again, ladies and gentlemen. That's some good level of success. You're very welcome back from the health break we've just taken for a cup of tea and coffee and relaxation, and I believe that you are well and all is going on very well. Thank you for your participation in the previous session we just had before break, as we were listening to Professor Serena about following the wave of international acceptance and understanding the potential of alternative dispute resolution in Uganda, which was very clear. So the tracks are continuing. The judges are down in Choga Hall, while the practitioners and end users of ADR will stay in this room as we now get to topic number 2, which will be about foundational work for understanding how mediation elevates thinking to move parties into problem solving. And we will be looking at the different best practices for mediation as we go along. And at this moment, we are going to have our training faculty to come to the front, as Professor Selina will be helping us to understand how that will be going. So please welcome Professor Serena once again with a round of applause. Good hand clap. Some of you who have clapped, may you also receive claps in life. Those of you who haven't, may you also receive claps in life. And we are going to be having the Honorable Justice Geoffrey Chiriabwire, Ms. Rachel Odoi-Musoke, Honorable Minister Norbert Mao, Mr. Francis Jimara, Senior Counsel, and our SG Francis Atoke. So over to you, Professor Serena, for the next lap of this engagement.
Thank you. I'll just get my cohort organized up here and then we will start.
Just to say that this session will be in 2 forms. We have topic 2 and topic 3, and both will lead us up to lunchtime. So once this session is done, we will be going for lunchtime, hopefully by 1 p.m.
Thank you. Welcome back. I appreciate you bearing with us while we get organized. I left you with the idea of starting to talk about the magic of mediation. And for those of you who have been trained in mediation and have done some mediation, you probably have seen that moment of magic where it seems like something shifts in the room. And as I worked with the cohort this last week, I asked them to share experiences. And I really would like to, Justice Kay had a beautiful example of this shift. So I'd like to start this session with his beautiful example of when this shift happened for him in a mediation. So Justice Kay.
Still doing morning. So good morning to everybody. We have learned that people don't really respond to good morning. I want to share with you an experience in the courts, a time when I was at the commercial court and we're trying to start scheduling in a more structured manner. And those of you who practiced, I think people like Alex and all would remember the growth of the scheduling memorandum under pilot in my court at the time. And so that allowed me, because scheduling at the time was not done in any structured manner. People would just come before the presiding judge and then go through what the issues should be and what sort of documentation should be worked out. But because I insisted that you write out what your cases would be and what you thought your issues were, I got an opportunity to look into what the dispute looked like. And so this dispute involved two fairly prominent businessmen in Uganda, well established, and they happened to have a contract between each other, and that contract went into default. One of the parties at the time was not feeling very well, and he had to be moved around by his son in a wheelchair. So when I got the matter before me, the lawyers came to do the scheduling. And I got the sense that the stakes were high, the positions were very fixed. But I wondered in my mind, of course, many of you who know my background will know that I came from the corporate world. And I sensed that really this is a matter which could be resolved if we had the principles in place. But the lawyers had taken positions and they were ready to go. And so I said, you know what, I'm not going to do, and those of you who came before me would know that my practice was very simple. You didn't get your scheduling done unless you came with your client. Because I used to say that, you know, there's only one person in the court who is allowed to get annoyed. And I mean, two people who are allowed to get annoyed. I correct myself. And that is the plaintiff and the defendant. In a court where you have the plaintiff and the defendant is annoyed, the two lawyers representing them are annoyed, and the judge is annoyed, you get pure chaos. So I adjourned that and I said, bring your clients. And so the clients came on the adjourned date. The first one was the plaintiff, who was wheeled in by his son. I was doing it in chambers. In those days, I did not have a courtroom, so all my matters were in chambers. And the other businessman walked in. So they looked at each other, they greeted each other, and they sat behind their lawyers. And I went through the process of trying to establish really if this matter could not be settled. And the lawyers started what they had done at the previous sitting, just going at each other. And I said, no, I'm talking to the clients, I'm not talking to you. Last week I spoke with you, now I'm talking to the what? I'm talking to the clients. And the gentleman, one of the gentlemen, the defendant, stood up and said, give us 20 minutes. And so we adjourned for 20 minutes and they went away. They went outside the court, and I can't recall really how much time they took, but they came back. And by the way, they went by themselves. They didn't go with the lawyers. They went by themselves. The lawyers went a different way, the parties went a different way. Then they came back, and the defendant said, "We have reached a settlement," to the surprise of their lawyers. "We have reached a settlement, and just give us time, we will record it and file it with the court." At the time, I did not get the immediate terms. They just said, "Look, we have settled, we've spoken with Mzee here." Mzee is an old man. And I think we will settle this matter. And so I said, "Fine, give us a time frame, and then you come back and file the settlement, and we'll turn it into a consent judgment. That will close the dispute, finally." And for Selina, in Uganda, when you have a consent judgment, you cannot appeal it. There are very few exceptions, so it's fairly watertight. It is for forever. And so I saw the young man pull back his father's wheelchair and push it towards the door. And the defendant came and pushed the young man away and took over control of the wheelchair and pushed the plaintiff to the lift. And they went talking like, they had just come out of a business meeting. It was done. That's the magic of mediation.
It's beautiful, beautiful. And for those of us who've experienced it, whether as a party or as the mediator, it almost is a high. You would like to feel that all the time. Something really important happened there. There was some type of shift into problem solving. And if I could have my slides put back up, that'd be great. Put back up the slides. There we go. Whoops. Could you advance it for me? One, it's not advancing. There we go. Great, thank you. So there was a really interesting study that took place, and it looked at attorneys who hire mediators. So this was a group of 50 high-end attorneys in the US across big cities. And this study was supposed to find out what do attorneys look at when they're picking mediators? And what was kind of shocking, it was not resolution rates. It was actually when they found mediators who got their clients to make smarter, better decisions when they had the pleasure of being with the mediator. So it was something that was happening. It was this kind of shift that Justice Kay just described. Some kind of shift in their thinking that made them be able to make smart decisions that were more grounded in their foundational beliefs, goals, values. So it really does feel like magic when this happens. And for most of us, that's kind of, as mediators, I hear some attorneys who've been trained as mediators and start mediation. When you hear them talk, it's almost like they found religion. It's almost like they've had a spiritual awakening. I have a very dear friend who I don't think I could have been dear friends with when she was a litigator. She was known around town as this very hard-nosed litigator. She was partner at a big firm. Then she went and was in-house counsel for FedEx. But when she became a mediator, it was like there was this shift from her. And so it does feel like this magical thing. But I read a book called Braiding Sweetgrass by a woman named Robin Kemmerer. And she talks about how pecan trees in America all fruit at the same time, all across the country. But it's never the same time. It's very hard to predict. You can't tell based on weather, and they're all across the lower south, but they all fruit at the same time. And so scientists for years were trying to figure out how this happened. And the Native Americans said, it's because the trees talk to each other. And the scientists, of course, thought they were crazy. The trees talk to each other. Well, now, years later, what have the scientists figured out? The trees talk to each other. They have a certain kind of mold that they release through their root system that travels to other trees and travels to other trees and travels to other trees, and they give signals so they all fruit at the same time. And what's pretty beautiful is just like those trees, the same thing has happened with mediation. Now that there's been so much neuroscience research done, there is real clear evidence about how setting up a really good mediation process truly does change how people think. You actually can elevate people's thinking, so it's moving from the back of the brain to their frontal cortex. So let's just talk for a quick moment, I'm not going to talk for long, about how your brain works when it's in conflict. There is a neuroscientist called Joseph Ledoux, and he talks about how our brains have no emotions in it. Psychologists talk about emotions, but he says there really isn't anything called emotions. What there are survival circuits, and the same survival circuit that protects our sense of physical safety is the same survival circuit in our brain that protects our sense of self, of our identity, of saving face, our ego, who we are. That is the same survival circuit. And so people who've gone through a lot of trauma in their life, they're going to have a stronger, thicker neuron connecting to that survival circuit in their brain. And my students know I really don't like to talk about difficult people because I don't think that's terribly empathetic, kind of others them. But if you get some empathy around the fact if somebody's hard to work with, they probably have a really thick neuron to that survival circuit. So I'm going to show you a simpler way to think about it than neuroscience, and I want to give credit where credit's due. This is a diagram from my dear friend Bernie Barrand, who I've trained with for years, and he thought about this more simple way to look at it. Let me just give a precursor. You saw the picture of my daughter's art in the conflict lab. Let me say, I am not an artist. Here is my picture. So this is a picture of me, hand in hand with me, but there's two different parts of me. One side is the problem-solving me. That is the part of me that will sit down with you and I will talk really reasonably and rationally about a problem. I'll figure out what my interests are and what your interests are, and I'll work with you to figure out how to get something resolved. But hand in hand with me is my identity guard. And my identity guard is protecting my sense of who I am. And it is just ready to get angry, offended, mad at you. And the problem is, you can't get to the problem-solving part of me until you get that identity guard to sit down. So it is always out in front, and it is not going to sit down until you've shown it great respect. And with those people who've been through a lot of trauma, or for some reason this conflict is really upsetting to them, it's going to take longer for you to get them to sit down and get to that problem-solving place with them. I hope that really resonates with you and sits with you. So this is the key. For mediators, the really important thing is to focus on providing a really good process, a really good, solid mediation process. And this might sound controversial. Mediators do not focus on getting to resolution. Does that sound, you can raise your hand and give me pushback. You can raise your hand if that sounds controversial. Didn't you think mediators focus on getting resolution. Where mediators misstep is when they focus on getting people to resolution instead of holding good process. Because we're going to talk about best practices to hold good process. Because when you hold good process, people's thinking is going to be elevated because that identity guard is going to sit down and they're going to start getting empowered to resolve the problem themselves. You're simply facilitating. It's not up to you. So I want to talk about how the first kind of pillars of setting up a good process, and I believe you've been shared with in your conference materials, the model standards of conduct for mediators that was developed by the AAA Association, the ABA, and the Association for Conflict Resolution. So these are the code of conduct standards that are used in the US and other places. And I know currently right now there has not been an adopted standard for mediation, but hopefully you can look to this as a possible code to adopt. But it has, we've talked about this morning, a lot of different types of mediation, and they're going to look a lot different. But these three pillars have to exist for something really to be a mediation. And they all have a very particular point to them. So the first one, there's the model standards for you to see. The first one is the idea of confidentiality. This is so important to parties because it gives them a sense of safety. What they say in the mediation isn't going to be repeated in court. The mediator can't testify in court. You can also develop mediation agreements to bind the parties and get them to agree that they're not going to share any verbal things that were said in court. This is often used in medical malpractice cases or personal injury cases where doctors can say they're sorry and take responsibility in the mediation without fear that that acknowledgement of fault is going to be used in court. So it's pretty powerful. You can also talk about different settlement ideas without concern that the mediator is going to say, yes, they talked about this settlement possibility, unless it's actually resolved. So that gives parties a sense of safety, helping that identity guard to sit down. The next thing is self-determination and autonomy. So I had a conversation actually with Justice Mike Chibita, and we had a similar situation with children in college. So you saw that my daughter is an artist, and there is a really good university in Pittsburgh called Carnegie Mellon University, and it's a really good art school. And I thought she should really look there, but I knew she would be very hesitant to look at a school in her city. So I knew if I told her, this is what you should do, and she was the youngest, so she was the one going to be most resistant to anything her mom said. So instead, I got a gift from God where my good friend's daughter, who my daughter was friends with, was going to be taking an art class for high schoolers at the university. And they asked Chloe if she'd like to join. So my daughter said yes. So the first weekend, we go and drive to the art class, and the campus is beautiful. So she's seeing this beautiful campus. We're driving up. Then we walk into the art school, and on the walls are beautiful paintings. Very talented art students clearly go to this university. And she noted that to me. I could see her eyes were really big. The second weekend we went, she said, she came out and she said, Mom, did you know that Carnegie Mellon is one of the top 10 art schools in the country? Our professor told us that. No, I didn't know that. Third weekend we go. I don't know if it happens at university here in Uganda, But in the US, there are students, current students, who do tours, and they'll have high school students, secondary students, that they'll walk around campus. So it was a beautiful day in Pittsburgh. It was fall and the leaves were changing. And here was a college student walking a group of secondary school students around the campus. And my daughter turns to me and said, "You know, I should look at Carnegie Mellon University." Bingo. So she came to that on her own. So self-determination and our sense of autonomy is so important. Another saying from my friend Bernie Behrendt is, if you insist, they'll resist. If they tell you, they'll follow through. And I heard a lot, and over the last week, I heard a lot yesterday, about agreements in mediation not being followed through with or not being enforceable if they weren't, as Justice Kaye just told us, a consent order. And it concerns me a little bit because there's a lot of research done that if you really allow parties self-determination and they really are part of developing the solutions, and it's not imposed by the mediator or it's not an evaluative mediator, the durability, or meaning that those mediation agreements are followed through, is very high. So that's one thing to think about as you're developing processes, to make sure that the participants are really getting to come up with their own ideas and be part of the solution. The third pillar is impartiality. And impartiality of the mediator develops trust. And I'll often ask new mediators, what do you think this means? And they will say things to me like, you spend the same amount of time with each party, you listen to each party the same way, you make sure you validate. They talk about it in really technical terms. And all of those ideas are good. It's good to spend equal time with the parties, but sometimes you're not able to. Sometimes you have somebody who talks a lot, and then somebody who's more quiet and is a person of a few words. They don't need to process their decisions as much. Sometimes you have one side that has a really complicated decision to make, but it's more clear for the other side. So actually, what impartiality means after all these years, it's really rapport. That you have good rapport with both sides, meaning that you have connected with them at a human level, and that's where trust comes from. So that comes through, and we're going to talk about some more ways that comes, but that comes through that connection with people and making sure you really understand their perspective of the case. So that is more important than anything else. There's many studies done on who are the most effective mediators. And what has been found, it's the people who can build the best rapport with the parties. So I think we all know the minister. The minister can make rapport with people in a matter of seconds. I'm sure he will be a very good mediator. That ability to make connection like that is huge because it builds the trust with parties. So those are the three pillars. They have to be in place for it to truly be a mediation. So I want to move on now to talk about these best practices now. Once the pillars are in place, let's talk about what are the best practices. And I really, I hope to instill these in, because I'll tell you, there's places in the US and other countries where they've lost some of the best practices of mediation and the process, and it can cause it not to be as effective. So let's talk about what they are. The first one is pacing. Pacing in mediation is so important, and it is going to, for those of you, everyone in this room, I'm sure, is quite a type A personality. because to be in the industries that you are, whether you're a lawyer or a banker or in the insurance industry, you probably get things done. You probably like to get things done quickly, and this is going to feel a little bit restrained for you. It's what I call slowing down to speed up, but it's very important in getting that identity guard to sit down. So I used to run marathons when I was in my 30s and 40s, and I ran about 10 of them, and I couldn't get my time to go down. I was very frustrated. And so I worked with, I was able to get into this study by a runner named Bart Yasso. And he told me, he said, you have to run the first part of the marathon slower than the second half. Well, that sounds terrible. So I have to hold back for the whole first part of the marathon and then save my energy, and that just didn't seem to make sense to me. And so I ran a marathon and didn't listen to him. Time still didn't go down. Finally, I thought, okay, I'm going to run one as Bart said I should do. So I did. I ran the first half, I held myself back, and then the second half, it was incredible. I finished with a time about 15 minutes slower than I'd ever ran. And I realized how important pacing is. And it is so important in mediation. There's 5 stages of mediation, and each one of them has a particular act that you're supposed to accomplish, something that's supposed to happen in the parties. So we're going to talk about these, and the cohort is going to help us to illustrate what these look like. So the first one is pre-mediation individual consults. This is the convening stage, and this can be done a myriad of ways. And I'll tell you, this wasn't the traditional way to do mediation, to meet with one of the parties individually before you have a joint session. But the research over the years has shown that it increases effectiveness of the mediation by 40%, both in resolution and also satisfaction, so that the parties felt like they were given a fair process. And the mediator's role here is very clear. It is simply to create a willingness for the parties to come to the table in full faith and to be totally engaged. And the mediator's role is pretty easy here if you can hold yourself back from problem solving. That's hard, especially for you attorneys, because you are used to looking at your client's case and evaluating it and trying to tell them what they should be doing next. But these meetings, really all you're doing is listening. That is the really important thing. You're listening, and then you're doing 2 things. You're validating the emotions you see in the party in front of you. And let me just tell you that anybody involved in a litigation conflict has emotions. I often hear that only family cases or land cases, those have emotions. Banking cases have emotions. Maybe they're just more hid, but there's emotions there. Insurance cases, there's emotions there. Maybe more hidden, but there's usually emotions there. The other thing is to validate and understand their perspective of the facts. You notice I didn't say that you're agreeing with their perspective of the facts. You're just letting them know that you understand their version of the facts. It is so important. This is what I call match before you can move. You have to let the party know that you understand their version of the conflict before you're going to have any success of moving them towards resolution. And that is because of the identity guard. That identity guard is going to stay up until they know you understand. And as we were going through this this course this last week, the Solicitor General had a great story of his own land dispute, and I would like to have him share because he has some good insight about feeling and emotion in a conflict. So, Solicitor General, would you be willing to share?
Thank you very much, Professor Selina. I'll not greet people because they may not answer. So allow me to dive straight into my experience because I don't want to go through the same experience like Samuel did. I had an experience with emotions, and I call it skills in working with emotions. I had a land matter in Lira where my brother had bought land 14 years ago, and he was in occupation. Doesn't reside there, but his son was looking after it, and it happened that I was always checking on that land. There was nothing on the land, and when we almost ended up in blows with some people whom we found digging the foundation, we thought we should share this with the local council chairman of the area. The idea was for him to mediate. Forget about the idea that he is not schooled in mediation, but we thought we'd go under the traditional justice system, whereby you sit down under the tree and you listen to each other. We sat under the tree, and the chairman called the meeting to order. He invited the LC2 chairman as well. So we thought we were going to talk about evidence of ownership, because for 14 years nobody disturbed us until that lady came up and said she was a widow. And you know, when people hear about widows, we tend to think this is a very vulnerable person. I normally try to accommodate them because I worked with them for 27 years. So I know what they go through. So when I asked her, she said her husband died, I don't know how many years ago. And I said, how then did this man who sold to my brother get the land? He said that man was supposed to keep the land. And for her, she was in the village looking after this man. I said, how long was he sick? That he was sick for about 8 years. And she had a boy who was about 12 years. I said, how, if he was sick for so many years, how come this boy is about 12 years? How was he fathered? Because he said the fellow was, he had some paralysis and he couldn't walk, he couldn't do so many things. So I imagine even that kid then could have been the son of somebody else. But we didn't go to that one because that was not we were not supposed to mediate that. I didn't know at first that even it was mediation until recently when Selina taught me about mediation. I'd learned about mediation earlier on, but I didn't appreciate that actually conflict is wired from the brain and it comes to our faces and then it is reflected and it is mirrored. And if your mediator is a person whom you don't like, you won't even listen to them, because the LC came, he was scratching his beard, scratching his tummy, and I mean, it was not the best thing to see, and I was already biased. He didn't listen to us. Like they had a pre-mediation meeting among themselves, not with me, not with my people. So when we came in, we said, can you please give us evidence of this land, how the widow acquired it? They said they produced a document and then waved it at us, said it is here, but I'm not giving you. I said, what kind of arrangement is this? You're not giving me, but you have it. He said, it is here, I've read it, and it is okay. And all the village was there. Everybody came there. And you know what? They even brought the media. They said, we want to show later, that's what I came to know, that this land issue, the Solicitor General is involved. And we want to show the President how Solicitor General is grabbing people's land. Because I've had numerous land cases, over 15. But because when I'm right, I follow it. When you want to mediate with me, I agree to mediate. But when you jump, then we go to maybe up to the appellate jurisdiction, but appellate level. Then we talked, even allowed the watchman to also speak. I said, the watchman is talking as who? He said, because where we are, it was in a school. He's the one who guards this school. So I said, what has the school got to do with my case? He said, but we are sitting in this area. So the whole thing was upside down, really. And you couldn't expect any justice from that. And I knew there was going to be no justice. So at the end of the day, the chairman made his ruling. Not that very day. He waited when I had come back. Then he made a ruling. And in that ruling, he declared that the property belonged to that lady. And I was already annoyed because in everything we do, in conflicts, the emotions, that conflict resolution, first of all, starts, like Professor Selina said, with preparing the disputants, bringing them, putting them at ease, analyzing their feelings, and going deeper and finding the interests that is under the surface. If you look at the surface only, I remember, Professor Selina allowed me to bring this up. Professor Stephanie Bell Brandel gave us an example of interest. There was this orange, and there were two boys who were fighting for the orange. And they couldn't. They were both crying. And then when they were asked, what is the problem? One boy said, I have certain ailment. Tomorrow my class is playing football, and I'm the best goalkeeper. There is no other person. And if I take this, it helps me. My grandmother taught me, it helps my asthma, if I remember very well. And they realized that that person wanted the orange. Then they asked the other boy, what is it for you for that orange? Why do you want the orange? He said, my grandmom, before she died, she taught me how to get the rind and mix it in an icing for cake. And whenever we do that for my birthday, it is so nice that my classmates ask me, what is it? What did you put in there? And it is his secret with the grandmother. So he wanted the rind. So when you talk about expanding the pie, that was expanding the pie. They got the orange, gave the rind to the other boy, and then the fruit to this other boy. And the matter was resolved. That is the aspect of that. And when you look at your clients, their feelings is very important. And I wanted to refer, if you permit me, to the feelings that brings in emotions. Mediation. Normally, people come to mediation when they are breathing fire, ready for battle, over my dead body. That's what you normally hear when people come through. Over my dead body, I will not leave this place. But then after that, if you get their feelings, you buy their trust, then they're ready to calm down because you are validating them. you are taking in their emotions, because negative emotions are very dangerous. Mediation succeeds based on capturing the client's emotions, and that's what takes it forward. So if it is not done, you get annoyed. I was very annoyed with this LC. I still see him even in the eye of my mind now, arguing and telling me that he will not listen to me, because I developed anger, hate, and I was very annoyed with him and his LC2 chairman. But with hindsight, when I look at it, I realized that he did not address the negative emotions that I had, because I had the contract, I had everything, I was there on behalf of my father for 14 years. And this person denies me the right. He was only listening to the other side. And he was allowing every other person who had no interest and no knowledge of how we acquired the land. And today, I may tell you, we didn't settle, but we went to court. I'm in court right now. And last week, as we were preparing for this summit, somebody called me. Another LC told me, do you know what? I got the sale agreement where this lady sold to another person. I'm dying to go to court. If they come for mediation, because now my emotions have cooled down, I'm ready to talk to them. And because the land is still there, nothing has happened to it. So, the emotions play a very important role. And at every stage, if you address the emotions, the feelings, and both parties realize that you are actually listening to them, you are empathizing with them, you are taking in their places, and even reframing, asking questions, maybe, oh, it must have been very bad. How much did you buy this land? Now, what do you think should be done? Those are questions that will cool down the tempers, will cool down your emotions, and make you feel you are being validated. Thank you.
Thank you, Solicitor General. You can see why he's the A++ student. I feel like I could sit down and just let him teach. Sir, good. Yeah, so important. And one of the things I want to point out to think about the pacing is that the research does show that at this early stage, if you start in these individual meetings to move towards problem solving, so to try and talk with the party about how it could be resolved, what about this, which our brains like to do, and we like to start evaluating it, the research has showed that it will actually have a negative effect on resolution. So it's so important to hold this discipline of just hearing what they have to say, validating. It sounds like you feel betrayed. It sounds like you feel very annoyed. You're very angry. You're just heartbroken about this, whatever that emotion is. And then being able to let them know you understood their version of the facts. Even if you didn't have your mediator hat on, you would think they were crazy. You gotta push that to the back of your head as much as you can and just validate what you're hearing in front of me. This is a really hard thing to do. There was research done by a woman named Nancy Klein out of the Friends School in England. She wrote 2 books. They're really easy to remember. They're called A Time to Think and More Time to Think. So easy to remember book names, but they're very good in the sense the research she did was trying to figure out how to elevate people's thinking. And when you read them, you realize that there's so much of that that is in mediation, especially in this first phase of convening and doing these independent meetings with people, these pre-mediation meetings. What she said is The quality of everything we do as humans is dictated by the quality of thinking we do first. So the quality of anything we do is dictated by the quality of thinking we do first. And what she found, which was so fascinating, is that people, can determine the level of thinking due based off of the quality of listening the people do around us. So the level of thinking we do is based off of the quality of the listening that is happening around us. And I feel like when I have attorneys in the room, they can probably relate to this, is that most of the time we're defensive thinking. So we're worried about somebody interrupting us. And so we're trying to get out whatever we have to say before somebody interrupts us, especially if we've spent a lot of time in court, right? We're trying to get it out. But when we realize that somebody is listening to us, especially if it's without judgment, and they're just really curious about what we have to say, the MRIs of people's brains show that their thinking moves to the prefrontal cortex, where we do all that problem solving. And what she found is when people are really deeply listened to, we are hardwired to start going from how our brain is spiraling in those emotions to start trying to solve our own problems. Powerful. So listening is a mediator's superpower. So a couple important things about this type of listening though. It has to be non-judgmental. You cannot ask questions. That's a hard one, right? You can't ask questions. You can't say anything. You really just have to sit. And this is the thing, our brains are so smart. We take in so much from somebody's face. So you have to really work on building inside yourself the ability just to have curiosity about what they're going to say next. You have to try and push away if you're thinking of the question you want to ask or what you want to say next. And this is really hard to do. So we do have the time to do this exercise, so I'm going to make you do it. So I want you to do this. I want you to find a partner right next to you. Hopefully we have enough even numbers. So find a partner right next to you. And I want you to do this. I want you to think of a story to tell them. It can be any story. It can be a story about your family, travel, anything, work. It can be a story about anything. And I want you between the two partners to determine who's going to speak first and who's going to listen first. And I'm going to give you just a minute to do this. And so if you are the listener, you're not going to ask any questions. You're simply going to listen and try and get curious about what they're going to say next. I'll give you a minute, and then we'll have a pause, and then we'll switch who's the speaker and who's the listener. So everybody take a moment to find their person and decide who's going to be the speaker first and who's going to be the listener first. I'll give you a moment to get that arranged, and I'll tell you when to start. Yes, question. Yes, go ahead.
Can we request the mobile microphone?
Yeah. Yeah.
I don't seem to be getting that aspect of validating their feelings.
Yes.
Is it that I should get involved emotionally in the conflict and start sympathizing with this side and the other side? What is to validate?
What's the purpose? Yeah, what's the intent? Yeah, for the exercise, it's just to feel this kind of listening. But if you were doing this in a pre-mediation meeting, you're doing both of those things. So while you're listening, you're trying to grasp what feeling you're seeing in front of you. Are you seeing betrayal? Are you seeing anger, disappointment? What is the feeling? And then you're also trying to get a really good grasp of their perspective of the facts. So when they're done, when they're finished, you can then relate back to them. You know, I can see you feel really betrayed, you know, that your brother took that land from you. So you could have a simple sum up statement like that. In this situation, they're probably going to be telling you about something fun, so you don't have to worry as much about it. But when you're in that pre-mediation meeting, that's what you're doing. Yes, good. Thank you for that question. I appreciate it. Okay, does everybody understand the exercise? Any other questions? Okay, if you know who is going to play what role, let me get my timer set so we keep you honest. Okay, all right. Okay, is everybody ready? Go ahead and begin telling your stories. I appreciate it. Stop. Okay. Oh, you're so respectful. You stopped right away. Great. Okay. So now try and clean your palate of that first conversation. And now the person who is listening is going to be the storyteller, and the other person will be the listener this time. And remember, listeners, you're just listening with curiosity. No judgment, no questions, no words. Okay. Ready? Begin. And stop. Very good. How is that? Do I have anybody with a microphone who could help us hear from a couple people how that was? Okay. All right, if I can pull you guys back together, I'd like to hear from a couple people how that felt. Anybody willing to share how that felt, either to be the listener or the talker? Hard, easy? If you raise your hand up, oh, over here.
Thank you, Professor. What I liked from my neighbor,
If I can get everyone to be quiet so we can hear the question. Thank you.
as I was talking to him, giving the story, he listened carefully, looking at me straight in the eyes with a high level of interest. Unfortunately, I did not finish the story, and then you stopped us. But really, he was a good listener, and I gave it a good time to hear from me.
Excellent. So it felt good to be listened to in that way.
Yes.
Yes, good, good. Other thoughts? Yes, right across the aisle.
I was doing the listening, and the whole time I was dying to ask questions.
Yes, yes.
But I had to keep quiet. I really had questions. Even after you called the time, I felt like, okay, maybe I can now ask questions.
Yeah. Thank you for your honesty. That was so. Can you keep the microphone for one second? Because I want to ask you a question. Can you give her back the microphone? I want to ask her a question. So, yes, I appreciate first off you being so honest that was so hard to do. Would you mind telling me what the story was and then what the question you wanted to ask was?
Yes, she, on her way here yesterday, she needed breakfast early in the morning. She came in by 7:30 a.m. And so she found that preparations were still being done. So she decides to go to a nearby cafe at Arena Mall. And then she gets there and they're not ready. Her breakfast wasn't ready. And she was getting irritated, so they delayed with her breakfast. She was hungry, she was irritated. It's early in the morning. And I was dying to ask her, why did you get there so early?
Yeah. So.
And then couldn't you have had breakfast at home? Why are you going through all this? Could have been avoided. But
So you were not only wanted to ask questions, there was a little evaluation in there. It's like, you should have got breakfast at home, right? Yes. So my question to your storyteller, if she would have asked you that question, would have your story gone in a different direction?
I'm sorry, could you just repeat that?
Sure. If she would have asked you that question about why didn't you make breakfast at home, would have the story you told her been different?
No, it wouldn't have.
Yeah. And I know this is just a story about annoyance over hunger for breakfast, but that can cause annoyance. But I want you to think more deeply about it. If it's a client, and even lawyers, think about this for your first initial client interviews. In our breakout session yesterday, somebody talked about when they got their LLM, how they had hours of interview, discussion, and instruction. And it's because we tend to break into people's train of thought, and then that changes what they tell us. So they might not tell us that really important thing that could have helped us figure out, as Solicitor General was telling us, what their interest was. So you want to make sure, especially in these pre-mediation individual meetings, you let them completely finish before you break in and ask questions. We'll take one more reflection about this exercise. What else?
Hello.
Hello.
By the names of Naomi Adong. I was the storyteller. The level of interest and curiosity my listener gave me really gave me it made me continue, gave me the interest to continue. Thank you.
Yes, it feels good to be listened to that way. And what the research shows is that relaxation. I want you to think about it. It's if you hear a very good athlete interviewed about when they do their best performance, they always talk about it when they're really relaxed. And so it feels really good for our brain to relax and just relay what's going on inside of us. Powerful, really powerful. If you do this type of listening with your families, they will really appreciate it. And they'll be, what did you learn at that mediation segment? So yes, try this with your families. It's great to do with kids. We tend to, with our children, want to jump in and tell them what to do and problem solve for them. But it's such an amazing show of love to people around you too, to listen to them this way. Good, okay. So moving on, we're going now into the next phase of mediation, which is the opening statement, the mediator's opening statement. And this is where I want to really underline best practice, because in the West Coast in the United States, there are a lot of mediators who have stopped this practice. And the normal practice for those of you who haven't had mediation training or who have not been to a mediation is the mediator will have both parties sit down together in a room with their counsel if they have them and give an opening statement. And this opening statement frames the process, the expectations. It gives people an understanding of what's going to happen during the day so they can relax. It gives some expectation of movement, and it is incredibly powerful. And let me tell you what's really powerful about it. And I'm going to reference some research done by a gentleman named John Barge. And John Barge did research on if we can prime our brains to certain behavior. And so he took a group of students at New York University and gave them a test. And in the test, there were words all through the test that had to deal with politeness. And then they were supposed to take their test and turn it in to the professor at the front of the room. Well, what happened is because they'd been primed with these words about being polite throughout the test, when they went up to the professor, they saw him locked in conversation, but they had been primed to be polite, so they didn't want to interrupt him. So they sat, and some of the students sat for 15 minutes waiting to turn in their exam. Then he did the same thing, except he put words about being rude in the test. This time, the students went right up to the professor, who again was locked in conversation with another professor, and interrupt him. Were terribly rude. And so it's just amazing. The other way he did the test, he had people come into a room, walk into a room, and sit down with him and do a little interview test. And he measured the pace that they walked into the room. Then the interview test he did with them had words to do with growing old, arthritis, aches and pains. In the US, this would make sense. Florida, wheelchair, hospital, all these kinds of words that would deal and get people thinking about growing old. And then he measured how fast they walked out of the room. And they walked out of the room significantly slower than they walked into the room. He had gotten their brains to think about growing old, and so they were behaving accordingly. So this research really shows us, if you have words about polite and being respectful, you can really influence people's behavior. And in the opening statement, you're really trying to build safety and hope that you can actually settle this case. But I also like to think you're priming behavior. You're priming an expectation that they're going to move, that they're going to treat each other respectfully. The other really good practice to do, if you've done these pre-mediation meetings with people, you can find ways to customize your opening statement to really affect the hearts and minds of the people in front of you. And so I want to give you an example of that. And so I want you to think about that case that Justice Kay told us about with the two businessmen And I've asked Minister Mao to give us an example of an opening statement using those two parties and to see how he could customize it for them. And so I'm going to ask the students to, the cohort, to move. We're going to have, if this will work, we're going to have Minister Mao move back a little bit. He's going to be our mediator, and the other parties are going to be the
Can
two
we have
parties
the
and the
mic?
two attorneys. Oh, that would work great.
That shows that I'm an African. Thank you, Professor. Dear friends, here we are going to actually do a live role play so that you really get it the way it is. So we are in a theater and you don't have to purchase tickets. We did not rehearse. So this is a cold one. So I am going to keep Justice Kiriabwire to remain in his position as the justice who experienced this case live. I am the mediator, and so I need to have the two parties. We will have the two parties as the two Francises, Francis Atoke, Solicitor General, and Senior Counsel Gimara. And Professor, permit me to assign you the role of one of the warring attorneys. So, Professor Selina and our classmate Rachel are the two attorneys. This matter came before Justice Kiriabwire, and he has referred it to me. So I will be addressing everybody in the court. Justice Kiriabwire is a silent listener because by instinct, he does not want to go up to the level of passing a judgment. So these two old men, Francis Atoke and Francis Gimara, according to what I have in my briefing notes, are businessmen. They are both pioneers in their field. They have achieved a lot of financial success. They are highly regarded in the society. And so I am now going to address them to demonstrate the opening statement. My Lord, thank you for giving me the opportunity to mediate. I would like to ask the attorneys to listen without interrupting. To the parties, I welcome you. I noticed that one of you came in a wheelchair being pushed by your son. So definitely this is very important to you. You want a resolution. And you are in court because each of you believe that you have a strong case. It's not my duty to make a decision. I'm not a judge. My role is to ensure that you identify the things that are important and the things that are not important. We know how much you care about this country. One of you was a pioneer owner of a major media house specializing in radio, and one of you was a pioneer of a major media house specializing in television. We know that your lawyers are determined to do their best so that one of you can prevail. But here we are now. I want to assure you that this process is private and confidential. There will actually be no records. I will be taking notes as I listen to you, but these notes are only for my own use. They will never be made public. You have complete control over what we are going to do here. And if you want to go and speak alone without anybody, you also have the right to request for that. This process has been extremely voluntary. You are the ones who wanted us to have this process, to listen to both of you. However, if you feel like it is not being helpful, at any given time, you can simply signal to me and tell me, I'm not interested, and you walk away, and we stop the process. You're free to take a break if you want. And I want to encourage both of you to be civil. Fortunately, you have both known each other since you were youth. As mentioned to you earlier, I am Norbert Mao. I'm a lawyer of about 30 years experience. I participated in the negotiations between the Uganda government and the Lord's Resistance Army. It was a very difficult negotiation. I have been part of delegations that have mediated conflicts in many countries in the Great Lakes region, Congo, Burundi, Rwanda, and Kenya. I have the knowledge, therefore, to advise you to reach a decision. You can simply call me Tom Sawyer. You don't need to call me any titles. Let us keep it informal. Some people call me Chairman Mao. You don't have to call me counsel at all. I believe that in this process, we both have the same goal. And according to what I've been briefed, you both have where you stand right now. But I hope that in the next few minutes, you'll move away from your original position so that what we see as a conflict is transformed. I want to ask any of you if you have any questions, and then you take charge of the process. My role is simply that of a facilitator. Any questions or comments?
Thank you, Mr. Tom Sawyer. I'm impressed. I hope you'll be able to sort out this problem that we have with my namesake and friend and business partner. But I wanted to know how long it will take to resolve these issues, because our businesses, mine is almost collapsing because he has refused to sign certain papers until I pay certain monies. So, Mr. Tom Sawyer, can you please help us resolve that problem? Thank you.
It is our intention that this process does not take more than 3 days, because I'm sure each of you are considering the options that are available. I urge you to keep your minds open, and let's be optimistic. Nobody's business is going to collapse. And since both of you are of advanced age, you definitely want to clear your minds so that your legacy is intact. Is there any comment or question?
Thank you so much, mediator, for this opportunity. I only came to court because my colleague and good friend has not been listening to me. I am very happy that we now have opportunity to talk to each other as old men, as business colleagues. That has been my problem. I hope you will listen this time. Thank you.
Thank you. This is a major breakthrough. The sound barrier, the wall is becoming a bridge, and it looks like we may not even have very much to do, since the two of you really want to listen to each other and talk to each other.
Mr. Mediator, I think give us time to get out and talk with my friend in the absence of our lawyers so that we can resolve and come back. And come back and sign the agreement. If you leave us alone, we shall go and do the needful.
So lawyers, this may not be good for business, but now that the two are going to talk, yes.
Beautiful job. Oh, so good. I would like to ask the audience, though, if we could just have a couple members reflect on what was good priming that Minister Mao did in his opening and what was good customization that he used that would be helpful to get these parties in the mindset to settle. Yeah, go ahead.
Yeah, I want to thank the members of the mediation team. In my understanding, these people are supposed to be very cold when they are coming in. And I think Chairman Mao did a very good thing, first of all, to introduce himself, to tell them his experience, so that he builds a base of these people putting respect and believing in him. They had to believe in him, first of all.
Yes.
We've known in the past where advocates were saying the mediator who was given to us was a small girl. We could not go and mediate before her. So what Chairman Mao did was to build that so that they open up, so that the two open up and brings them closer. He, of course, also tried to bring in the purpose of the mediation by saying they would be their own judges in this matter. The decision would be theirs, which I think in their feeling empowered them towards let's go and discuss, we shall come back. So those assurances, the issue of confidentiality did not come out very clearly, but it should have come out very clearly so that they are not scared that what is going to be said here might be repeated outside. So while he said there would be no records, he did not give them assurance that he was not going to discuss it at the club where he normally goes. So that one I think would have come out. A little emphasis on the advantages that would be obtained from mediation would have also added flavor to the opening statements. And of course, possibly he assumed being media people, they knew the language. He should have found out which language do they prefer to do this discussion in. And if there is...
Professor, and thank you, Chairman Mao, for the wonderful presentation. I would like to talk about the validation of their commitment to come for mediation. I thought Mao did extremely well by saying, thank you for coming. I see that one of you is in a wheelchair, and we all look forward to a resolution. I think that primed them to help them resolve their conflict. What I would have done differently, Chairman Mao said, I just want to quote him verbatim.
Don't want to misquote the minister.
I have the knowledge to advise you help resolve this matter. I think a mediation being a collaboration, you don't put yourself as being superior to those you are helping resolve the matter. So I would eliminate I and make sure that it's as inclusive as possible to the other thing. I would also start with the introduction at the beginning to let the parties know of who I am. But remember, you talked about self-determination so that they can determine for themselves whether I am the most appropriate to resolve their dispute from the very beginning. I've been involved in mediation, and I get a lot of opposition sometimes that, look, he's also dealing with tax matters, and we cannot have him mediate our tax matters because we will get to know the secret. Or he did practice with this firm, and we are now with them, so that would also be important. And finally, I would have gone to explain the process a little deeper to the parties. I think that came out in the question Solicitor General asked him, how long will it take?
Yes.
So if he had spent a little more time to explain the process of mediation, I think that would have perfected. Otherwise, thank you very much, Chairman Mao. Thank you, Professor.
Thank you. Thank you. Great notes. Yes. He really underlined their commitment. It took a lot of effort for him to come in a wheelchair, and he's, not at his best, and he still came. So he must really want to resolve this. But you also bring up a good point about really wanting to make sure the mediator isn't advising, that really they're facilitating, and the parties are coming up with the resolution, and the idea that process, understanding the process, is really important at this point. Thank you for your good comments. One more, yes.
Thank you. Listening to the two previous observations, I think Tom Sawyer did very well in that short time to bring out what he did.
Yes.
There are many other things that you read us through this morning that you cannot achieve in that short time. That said, though, there's one bit I would have done differently. The bit where he gave the parties the option of saying, if you fail, you're also free to walk away, or the consequences of failure and so on. In my experience, that comes later. If you notice that there's some progress, but it's stalling because someone feels maybe it's not worth it, then you start reminding them of the consequences of the other options. But that's much later, not in the opening. And that is driven by the tips you gave. Like we are often told, the needs of men drive their motivations. And when you are keenly aware of that, then you are able to try and understand the needs of each party, what motivates them, what even motivates them to be angry, to be able to guide the process. So that's a bit that I would definitely have done differently. Thank you. And Mr. Toki, on Thursday, don't forget, in the other boardroom, and call him Tom Sawyer. You might need Mr. Jock's services after that.
Thank you. Yes, we did give the minister I gave him a time limit, so he did do a very good job with the time that he had. And I do want to point out, as mediators, you know, you want your opening statement to be fresh and customized. I see some mediators kind of be canned, and so they have a pre-written script. So maybe it helps you not forget things. However, I would argue that it's better to have this more customized, free-flowing opening statement where you're connecting with people. And then if you miss something, just like the Solicitor General did, he had some questions, they'll ask you and you can fill in the details. The most important part of the opening statement is to give them that safety so they feel safe, that this is a safe place to have this conversation, hope that it could actually settle. So some hope that that can happen. And I also think the priming piece, thinking of ways you can prime them for good behavior and moving forward. So great, thank you. Good, well then we're gonna move on to the next stage, which is really the information gathering stage. And this can be a place where parties want to jump into negotiations, but this stage is really the place where, as the mediator, you have to have discipline to keep the process open, to try and make sure that you have all the information you need, the parties have all the information they need, because in the next phase, you're going to be working on the options and negotiating. So you want to, this is like putting money in the bank of understanding. So there's so much information that is going back and forth in this information gathering stage. There's information that you're getting about their interests, about their emotions, what's really driving them. But then there's also the concrete information about, you know, do you have any evidence about this, or any of the details about the situation, the options that can be created. This is where you want to gather them. Sometimes this is a really good place to have parties come together. One of the things, if we were doing a big, long mediation training, I would stress to you too, is the fact that you want mediations to be everything that you do as the mediator in the mediation. You want it to be deliberate and thoughtful. So I really want to encourage you as you mediate and as you pick your mediators, that they're mediators who think through if they are going to have parties together in a joint session or if they're going to be in caucus. That it's not simply we start in joint session, we move to caucus, we don't come back together until the end. Sometimes the information gathering space is a really good place to have them come together. I think of a case I did with a tech company, and I really didn't understand what was going on with their software development. And so I had both sides come together, and I had a co-mediator in that case, and we could ask them questions. And what was beautiful about that, it let them be in the same room and start problem solving and thinking in a different way instead of thinking like this against each other. And so I want you, for the information stage, to be making sure you give time for it, and you also maybe are doing some time together with the parties. So that's very important. Because of our time today, I'm not going to spend a lot of time on the information stage, but I'll just say the pacing part is sometimes if you have a day-long mediation, I will tell parties we will not start doing back and forth offers and demands until lunchtime. And what that does, they know that I've set that out from the beginning, and so it lets them exhale and just focus on the questions that are getting asked back and forth, and it makes for a richer conversation because people aren't so stressed about what offer and demand they're going to give. They're more focused on, okay, let's get all the information out, let's ask all the questions we want of the other side. And it really does help to get that identity guard down, because it feels like we're all working together on this problem. And so if you can hold them off, as hard as it is, if you can hold them off from going into negotiation until the afternoon, especially if you can have them sit down and you have lunch together. Beautiful. I didn't show you the picture, but at the lab we have a big kitchen, we'll have food. Food at mediation is definitely a best practice. You want to take care of people's creature comforts. I really doubt Ugandans have trouble with that. I've been fed very well since I've been here, but that is a really important thing in a mediation, is to make sure that there's food, and that's something nice. If you've done the opening and the information gathering in the morning, you can have lunch, and then in the afternoon, you start working back and forth in numbers. And I promise you, if you take that time, the negotiation will go faster. If you hold off until starting later, it actually will end sooner. I know that's hard to believe, but trust me, it's like that marathon. So the next phase I want to move into is then the negotiation phase. And thinking about in the negotiation phase, I think one really hard thing for all of us who've been in certain types of disputes over and over again is staying open and helping the parties stay open and not attached to outcome, meaning that they're open to this resolving in a different kind of way than we might think if we were the judge in the case, and that we're not attached to some certain way. We're going to be open to offers and demands from the other side, and we're also going to get creative and try and figure out the best way. And this kind of problem-solving conversation where parties are using the information they got in the morning and now starting to figure out what are the different options that we can use in this case. So I want to turn to our cohort again, and I first will start with Madame Rachel to talk to us about, she shared a story where she was the mediator, where this was something she had to do. So I'll give it over to you, Rachel. Oh, I lost my mic. Can you hear me? Rachel, do you have your mic? I'll let you go. Go ahead.
Thank you. For many of us, when and I think we've already seen it in some of the questions and some of the discussions that have taken place, the most important lesson we need to remember as mediators is that we don't own this dispute. We don't own the issue that's before us. Our responsibility, as we've seen in the opening statements, is to listen and to work with the parties to craft their own solution. For many of us, it's very natural for us to listen with questions. We've already seen from some of the exercises today, we already start crafting our own questions. We already start applying our own biases and our own thoughts. And the most important thing for us to do is to remember that we are facilitators, and at the end of the day, it's these parties who have to work through their solution. So what's important for us is to be able to listen to the facts, and to help the parties also to listen to each other, to begin to process the issues, to identify what their interests are, and then from there to start to work out their own solution. Because at the end of the day, it's the parties who have to live with whatever decision has to come out of this, and not you as the mediator. As a mediator, once the issue is over, you're going to walk away and start on a different matter. So it's always important for us to remember that we may have our own personal opinion, we may have an idea of how we think the matter should end, but that's not what's important, that's not what matters. At the end of the day, it's what do these parties want to get out of this? How do they want to resolve their issue? Have they come to a point where they can resolve? The experience that I shared was a mediation. I think these are... Hello? I think it's back. You can just bring it on standby. So this was a mediation that I handled many years ago. It was a dispute over a child. It was a mother and father who had a dispute over a child, When they initially brought it, the child was living with the mother, and when they brought the dispute, initially it was about maintenance. It was a mother asking for the child to be given money. But as they continued to discuss, it became more of a question of who should actually look after the child. So it was in essence a custody dispute, but couched in very many different issues. And as they went back and forth over the different problems and the reasons why they felt they were best placed to look after the child, I had my own biases, my own mindset. As a mother, I thought to myself, this doesn't make sense. Which mother would want to be separated from her child? And of course, we have this perception that any child, this was a girl, she was a girl of about 4, and we always say any girl below 7 years all children must remain with their mothers. And I had all these issues running through my head. And as they were discussing, I had already formed my opinion. This is a young girl, she's only 4 years old, she must stay with her mother, that's in the best interest. We must find a way of making this man pay maintenance. But they discussed, they went back and forth amongst themselves, and at the end, they agreed that the father would take custody of the child. And actually, the father left with the child that very day. And it was their agreement. They signed it off, and they were very happy. I went home actually very depressed. I just could not understand how I could have allowed this to happen under my watch. It bothered me for a long time. And what I realize now is that I had put too much of my own sentiments, my own emotions, my own biases. Fortunately, I was able to hold off enough for them to come to that resolution. But the story has a good ending, because about 3 weeks after that, the father came back with the child. The child actually looked much happier than she had the first time she came. She was a very happy child. And he came back and he told me, he said, I just wanted to come and say thank you. For everything, because we are all very happy. The mother was able to go and do some other things for herself, and they were all very happy. And that gave me some satisfaction. But I think the lesson that I got from that is that we don't own these disputes. These are not our problems. And our role as the mediator is to help the parties understand their issue, appreciate the underlying issues, and come to a solution that works for them. And at the end of the day, if we're able to do that and come to a solution that they can live with, that works for all the parties, in this case it worked even for the child, then we would have done our job as a mediator. So as we go through the negotiations, it's important for us to step back and hold our own thoughts, hold our own emotions, hold our own biases, and allow the parties to work through the problem until they find an appropriate solution. Yeah, thank you.
Thank you, Rachel. What I love about this cohort, which I think you can see, is they have a lot of self-reflection even as they go through the courses, to think back to cases they've already handled, and it's just a joy to work with them. So, the other piece that came out to me as I was working with the cohort, Senior Counsel Francis and I had some conversations, and he clearly is a convert to mediation and to the problem solving that goes on in it. He was talking, I sometimes call myself a recovering lawyer, because my mindset has changed in such a different way, and I think that may have happened to him, and he's been inspired by some negotiations. And so I asked him if he would just speak a little bit about the problem solving and what he's seeing.
Thank you, Professor. I've been positively impacted by the mindset of mediation in my work, and I have slowly began the transition into deepening that mindset, because I have actually found from the disputes I've been handling lately that if we looked out of the traditional scope of being trained as litigators and having litigated matters, we begin to see that perhaps there is a better way of resolving disputes. We also begin to understand that maybe litigation has been overemphasized at the expense of truly available mechanisms that can resolve disputes effectively. Small one that has been happening in this jurisdiction, a very funny one. Somebody is removed from a WhatsApp group. He goes to a court of law. The court agrees with him, issues effective remedies to prevent others from throwing him out from the group. He goes to the group, and they make him an admin, and people exit from the group. So you ask yourself in that question that, well, you have won, but have you truly won? In the truest sense of the word, have you won? You have a judgment, but have you won in the community? Maybe not. But for me, I've been touched by a recent case I handled, fairly big subject matter for this jurisdiction, but a banking dispute. And it came to me with instructions to litigate against a bank immediately because the bank had issued a recall notice. So go to commercial court, file, injunct the bank. So I looked at it, and of course the client was insisting, what are your instruction fees? Honestly, it was very, very tempting in terms of the value of subject matter. But I said, give me opportunity, send your finance team and your internal auditor, we look at this matter. So we block an afternoon, we go through the matter with the internal auditors because I want to really understand what the issues are. By close of the day, one issue would not be resolved, that some money was borrowed. That one, there was no explanation that an agreement had been signed, it's not being contested, money had been dispersed and used by the business in its operations, but of course, the business had been negatively affected by a slow market, and one of their major clients had really, withdrawn, and that left them in a very difficult financial situation. So over time, they had not been paying up the loan. So fines and interests increased to almost a half of the facility itself, the original facility. So after I looked at the matter very critically, I then told the client, this is not something that I am comfortable litigating about, but maybe let's try mediation with the bank and see. So we approached the bank and we started to talk. And eventually, we told the bank, if this last disbursement is paid, is it possible that we revisit certain aspects of this facility? But also, can you as the bank, because they normally tell you when the bank wants to issue you facilities, they will be at their best. But when you default, they will send the toughest team they have. So you see at taking facility, the very good side of the bank. That when you default, you see quite some tough people to negotiate, but that is what it is. The bank needs its money at the end of the day. For me, I sat down and asked the leaders of the bank. The client also had some valid issues, you know. Said, please look at this issue, look at this issue. But for now, I want to give you opportunity. Sit down. You, the bank, at the highest level, together with the client. Let your legal team and myself stay aside a bit, just for about a week, talk to each other. So, thankfully, the leader of that bank has a mediation mindset. He sat down with the client for about 3 hours one evening, and they made very, very good progress. So the client calls me one evening, he says, I think I have been listened to. Let us stay the case, and let us try out what I have agreed with the bank. From that incident, I learned many things. One, where they were going, of course, the company was going to have difficulty in court, perhaps was going to collapse. But for Ugandan standards, it's a fairly big company in terms of balance sheet, standing. Then I looked at myself again and asked the question, if I had gone to court, would it have helped or worsened? I am persuaded that we are in a far much better place, because if this company survives today, I have more instructions, 5, 10 years in future, not even me, but the lawyers who they can instruct. And also citizens will be employed, and also generally all of us, tax-paying company, pay taxes, and hopefully the government will use it well. So in that mix, I have asked myself as a lawyer, and this is just one, but there have been several, and this is, I think, the transformative mindset we need to ask ourselves. Where do we win as lawyers? Is it through being better lawyers or being better human beings, helping solve societal issues? I submit that I am persuaded that a mediation mindset today will make me more relevant for my country, and it will involve me to get solutions that move people from the language. There are two languages. The language of law, where everything is legal. We hammer and hammer and hammer, using the law, the jurisprudence, and everything. But there's also the language of interests, which requires us to have a mediation mindset, to understand interests and help people negotiate around their interests. I prefer that language because it's truly transformative in many ways. Thank you, Professor.
Beautiful. Thank you very much, Senior Counsel Francis. So we have a little bit of time before lunch. We've actually ended our good material that we wanted to present a little early. And this afternoon, let me just tell you what's going to happen after this afternoon. We are going to come back and we're going to do an exercise that will, in some groups, that will allow you to try and apply these best practices to a scenario. And then as part of the registration, you were asked if you had a question, And so our team, you'll be glad to know you gave this very senior cohort some homework because they were given that as their paper for their residency, is to respond to all of your questions. And we have divided those up, and so they will be responding to the questions that were submitted. However, as you can hear, the cohort, I mean, for many of them, this has been a long journey with mediation. This MDR is just a continuation of that journey. And so I would love to, since we have a little bit of time, to give them a moment to see if there's any other wisdom they would like to share. Cohort. No wisdom?
I think I'll just share a few ideas about how you all as practitioners can really be partners in this effort of mediation. And for me, when I was being trained as a lawyer, I was taught the 3 Ps, and I don't know if you remember them. Does anybody remember them? Anyhow, I know you won't answer because I know you know. The 3 Ps are prepare, the second P is prepare, and the third P is prepare. You don't go into this kind of alternative dispute resolution mechanisms, cold. You need to have a strategy. You need to have a strategy, and there's this book, Getting to Yes, and I don't know if you have come across it. I would really recommend it, because it says with each strategy you need what is called a BATNA. That is, what is your best alternative to a negotiated settlement? In other words, what are your options? And I like to think it as a series of strategy A, strategy B, strategy C, and you have your bottom line. What is the bottom line within which you cannot close a deal? And I think for those who are just having a straight mediation involving money, it is that point. It's that point at which you think that this is not going to work for me. So you can start like, many of our, and I like using this illustration when I talk about mediation. Walking down Kampala Road and you find an accessory for a mobile phone. The first thing that the seller will do is give you a price which he knows that only if you feel that you have a lot of money in your pocket you pay for. And then you would say, no, you cut. So you haggle, you bargain, and you come to a compromise. That's a very simple, straightforward, linear type of bargaining that you can do. Say, where exactly will I cut off? And perhaps my friends in the banks, this is the sort of thing you'd want to look at. Because at the end of the day, I have always said that most of these disputes arise out of people who know each other. It's very difficult to have a dispute with someone you don't know. So if you're a bank, this is your customer, you probably has been with your bank for the last 15 years and has taken the first loan and gone straight into default. And they've done a lot of good banking with you, but that one went wrong, either because of COVID or whatever the situation may be. So you may know exactly where you want to cut off, or you want to, as there's a technical term here, expanding the pie. Just look at other things that can help the businesses to run, your relationship. You say, okay, if I give you this deal, will you give me will you move an account from another bank to me, so something like that. I see my friend is looking at me. But this, what I'm saying really is that you really need to prepare. Don't go into these things unprepared. Do talk to your clients and see what options you can work out with them. Because I sense many times when we do mediations, especially those which are court annexed, the whole thing seems to crystallize when they enter your mediation room. That's when everybody now starts to think, oh, right now we're here. Now how do we progress? Nobody has an answer. Nobody has a first offer. Nobody has. So it becomes that breaking that ice becomes extremely difficult. So I think it is important that you treat a mediation in the same way you would prepare to go before a court. Do people prepare before they go to court? That's a story for another day. But let us assume we do. And prepare for it, have your strategy well laid out, and go with an open mind. So that is what is happening now. The problems that we have seen, and I was discussing this yesterday with some of the people during the break, we have started something like appellate mediation, and it has been thought that I can't negotiate because I have a judgment. I can't negotiate because I already have a judgment. That is true. But several things may happen. You may have an award of 100 million Uganda shillings, and you know what? The Court of Appeal will reverse it and say you have zero. So never be too confident about that. We have had situations where we start it, and everybody says no. We hear the appeal. For us, we are very confident. They walk out, and the clients walk back quietly, and they sign a deal. And that just shows that there was just poor communication between the lawyer and the client. I thought I'd just throw in that one.
Great. Anyone else want to end? Do you have something, Francis? Go ahead.
Thank you very much, Professor. One thing that I've learned from mediation, or the ADR in general, is that there's a lot of psychology in it. And what we have been talking about, opening statement, priming, involves psychology. Because you have to put the parties at ease. And how do you do that? You need to study them. There are some people who are termed in psychology high conflict personalities. You greet them, they want to fight. So you have done nothing, but you just greet them, how are you? Hey, what are you telling me? Or something like that. And then you need also to know what they call difficult conversations, what you are going to bring. Parties go for a hearing, and then maybe you want to tell somebody that, you see, they have not bathed, for example. The body odor is not very good. How do you tell a person like that kind of thing? You may say we need to observe hygiene here, so that a wise person may take whatever you are saying. But you can't you have to choose your words very carefully. Otherwise, you put them against you. And if, like I said before, if a person doesn't like you, whatever you say will just be turned into negative, because there's what we call cognitive biases. You need to study all those and look at the parties you are dealing with. And this goes to what Selina was talking about the magic of mediation. It is not like going to a witch doctor and then doing some other traditional things, but it is about how it is approached and how it is addressed. So if you look at the interests, if you listen, you look at the personalities, you may bring some questions in a roundabout manner if you know the kind of persons you are dealing with. And if you study them carefully, then you'll be able to address the underlying issues. But if you just dive into the discussions, maybe you put them off and you drive them away from coming to you. Just like what the senior counsel was talking about whether you have won a case when people have run away from your group. You have been put back, but they have run away from the group. In the end, even if you have a court order, have you won or not? So you need to study the people that you're dealing with and bring them on board and build that trust in you. You have a rapport, you have that trust. It is the most important thing that I see in mediation. And this all comes from the psychology. And there's what they call psychology of conflict management, which is very, very important. That I think, Professor Selina, that is something which I did not know that existed in mediation. You thought you'd just go to school and then come up with your degree or certificate, whatever you have, and say, today I'm a mediator. It goes beyond that. It goes beyond studying the minds of people that you're going to deal with. And sometimes it is a gift. I think that gift, Professor Selina, you have. When you are talking about, when you brought out this topic this morning, I think I was in conflict with myself, but then after listening to you, certain things started changing, and I thought I started becoming happy. And I didn't know what was making me happy. When I went for breakfast, I realized when I went for break tea, I realized it was you who was making me happy. Thank you.
I am honored. Thank you so much, Solicitor General. Well, that is a good thing to pause on, is you can keep getting deeper and deeper and developing these skills and learning the psychology of people. And it is a craft. And I hope that we have presented to you this morning that your goal is to create a process to elevate people's thinking. And that's the magic, is that process, and not to push people towards resolution. And that's done with a lot of discipline and thoughtfulness. So this afternoon, we'll take some of your questions. Hopefully we'll have some time from the floor, but we're actually, Yeah. We can do one question. We have 4 minutes, so somebody has a question?
Microphone.
Thank you very much, Professor. Justice K was talking of the impatience of banks at times in the failure to give a chance to a person to rectify structural faults in non-payment and so on. I think, and yesterday we had the lady who works with the bank saying they are very ready to allow in mediation and so on. But really, practically, that's not what happens. We are thinking of people going for mediation, but leaving behind their anger. They should not come with anger in the mediation.
Yes.
You have an advocate for the bank who is saying, I'm not allowing anything. For example, in the month of May,
a debtor is saying, I'm willing to settle if you are going to allow me to begin payment in September. And the banker said, no, I'm not going to allow. You have disturbed us too much since last year. So he or she jumps. So the settlement that would have been there fails. We must therefore hear. He forgets that if you're going to fix this case, you are going to call witnesses, you are going to reserve submissions, you are going to deal with judgments, you are going to deal with applications here and there, and then wait for judgment. And the courts are given 60 days within which to, so 2 other months, you are in December. Yet he would have got a judgment in May. Because if they had agreed and the man settled and said, I'll begin paying in September, there would be a judgment. So when they are doing this mediation, let them calculate what is my benefit if we settle now. Instead of having a judgment in 2024, you rather get it in May 2023 and then do the execution, because normally there is the default clause. Do the executions in September when he defaults. So it calls for patience. The 3 P's again come back, but this time on the other side, for patience, people, and preparation, they now move on to the opposite side.
Yes, no, thank you. I want to address the issue of the advocates, because we did have in the role play this morning, we did have the 2 advocates nicely step aside, and with 2 very prominent Ugandan businessmen, that's probably what would happen. But if you had 2 less business-equipped clients, that's probably not going to happen. And so I just want to point out that identity guard and the problem-solving part of a person, lawyers have that too. So as the mediator, you have to navigate that too. You have to be respectful enough to the lawyers that you can maybe get them to sit down and let you do some problem solving with the client. But I feel sometimes mediation programs make it almost seem like mediators can always do that. We can tell the attorneys to step aside and just deal with the clients. Well, that's not happening. I remember doing a mediation in New Jersey once for Home Depot, and the lawyer told me not to look at his client, like stuck his hand in my face and said, you talk to me. So I had to talk to him, and I couldn't talk to the client. So it is, you have to deal with everyone who's in front of you. They all have identity guards. And so maybe you're reality testing and talking about, so if you don't settle today at mediation, tell me the process. And you would obviously do this in caucus with them in a separate meeting and get them to walk you through what the process is so they can maybe evaluate, maybe we should take some time today to settle. So we are right at time, and I promised I would keep us really on time yesterday because you were all so lovely yesterday to stay late. So your lunch is ready. Thank you for your participation and good listening in this session. And thank you to the cohorts for your great job and great comments. Thank you, everyone. We'll see you back here at 2. Excellent job. Excellent job. No Tom Sawyer moments. It's great. You guys did great.
It's very important, ladies and gentlemen, that we appreciate this team of awesome people for equipping us with wisdom, knowledge, and understanding. You know, it's one thing to give knowledge, it's another thing to give wisdom. Knowledge is the acquisition of facts. Understanding is the appropriate interpretation of facts you've acquired. But wisdom is helping people to know the application of the facts you acquired and rightly interpreted. So we want to thank the team for not only dispensing knowledge, but also enabling understanding and therefore catalyzing wisdom. Thank you very much, team. We appreciate. This is the moment for lunch, and kindly stay where you are. The team at the back is just going to swing into action in the next few seconds to give each one of us a coupon that is going to enable us to go and enjoy our lunch. And when we come back, we will be continuing with what's happening right now. Now, the lawyers in the house, there is an attendance form moving around, a number of them moving around. Ensure that you register yourself, because you know this has important professional implications that are positive once your name is on that list, so that you are able to earn a few units and points here and there for your professional self-positioning for greater things ahead of you. So there is an attendance form moving around only for lawyers. Ensure that you register yourself. Bon appetit. The registration form looks like something like this from ICAMEC, so ensure you look around for one and register yourself. The lawyers.
Recording stopped.
If you're happy and you know, clap your hands. If you're happy and you know, clap your hands. If you're happy and you know, and you really want to show. If you're happy and you know, clap your hands. If you're happy and you know, say I am. If you're happy and you know, say I am. If you're happy and you know, and you really want to show. If you're happy and you know, clap your hands. I have a few happy people in the room, and that makes my afternoon. Ladies and gentlemen, you are welcome back. Let me request you to turn to your neighbor, shake their hand, and say, welcome back, my neighbor, welcome back, my neighbor. Shake the hands of your neighbor and say, welcome back, my neighbor, welcome back, my neighbor. I hope we had a good lunch, and now we are back for the session, and Professor Selina Schutz is ready to take us through the practical exercise as practitioners and users. So I would like you to put your hands together and welcome her afresh as she takes us through this fresh session. Round of applause for Professor Selina. Over to you.
Thank you. I hope everyone had a good lunch and enjoyed time together talking with your neighbors. We're going to do a practical exercise, and we knew we'd be a large group, so we're going to work together in groups of about 6, and the cohort is going to help group you. So they're going to be coming around and helping to group you, and also giving you a handout. So we'll do that in a moment and get you grouped, but I think maybe it would be helpful for me to go over the exercise while we're all together before we start moving around. So the exercise we picked for you to do, we thought we should pick one that was a banking dispute. We thought that would be helpful since some of you are in the banking realm and deal with banks as clients. So the situation we're going to give you is called Computech, and it is a dispute between a computer technology company, an IT support company, and a bank called Golden State. And you'll have this information in your facts, but let me just tell you a little bit about it. Golden State, as a bank, has hired Computech and has a 10-year contract with them. The contract Golden State is paying $1 million per year for their IT support services. The contract is in the very first year, and Computech decided that its team needed some additional training to be able to service Golden State's needs. So they went on this training, but unfortunately, or fortunately, depending who you are, the best trainer in this area likes to do his trainings on a yacht in the Bahamas. So the whole Computech team went for this training on the yacht in the Bahamas, and now it is the end of the year, and they've handed Golden State, the bank, a bill for $30,000. And they have said that it is industry practice for IT companies to be able to pass through the cost of trainings to keep their skills up to their customers. Golden State does not agree with this and believes that they should not have to pay this extra additional $30,000. They also have the bank has a very strict rule that they will not pay for trainings for their own employees. So this is particularly troublesome to be given this bill for training for one of their contractors. So we're going to give you the material that has both the basic facts for this case and then also both sides' particular interests. And we just want you to take a little bit of time thinking about if you were the mediator in this case and you'd gotten this information slowly through a pre-mediation meeting with them, and also maybe an initial joint session. And we want you to think about a couple of things. The first one we're going to ask you to discuss as a group is how could you take this information you have on both the parties and customize a good opening statement to prime these parties for resolution. So you saw the Minister Mao do a really beautiful job of that in our earlier demonstration. So I want you to think about, in this case, what do you see in this scenario that you could be able to bring up and use in the opening statement to start priming them to move towards resolution. Then for each of the parties, I also want you to look at these facts and think about, if you were one of these parties, how would you be feeling in this situation? Maybe it's going to be easier for those of you who are bankers to think about how you're going to feel in this situation. But try and think about what emotions, feelings you're probably dealing with each side, and how you'd have to validate that with them. Then remember how we talked about it's so important at this early stage of mediation to be able to show a party that you understand their perspective on the situation, on the conflict. What is their story in their mind about what has happened? So then we also want you to spend some time talking as a group is what would you have to verify as far as perspectives for each side, so they knew that you really understood how they viewed the conflict. So we're just going to take about 20 to 30 minutes. Probably going to take us a little bit of time to get you into groups and get you the papers. But we're just going to take a little bit of time talking about it, and then we'll go ahead and do a debrief where I'll ask some groups to share with us what they came up for each of the questions. Any questions about the exercise before I start having the cohort help me get you situated? Okay, all right, we'll go ahead and start moving you into groups and giving you the handouts. As you work through with your group, if you can pick somebody who will be the spokesperson for your group, and then we're going to choose a group to answer each of the questions. So, and the questions are still up on the screen. If you can just work through those once you've gotten a copy and had a chance to look through it. We're going to give you about 10 more minutes, and then we're going to hear from the groups. No discussion taking place yet? Okay, you're all reading. Okay. Yes. Still reading. Okay. Should be giving them homework. And Andrew did recommend that. He did. All the details. You gotta know it all right. Can you debrief it? approach things, and you start to realize how lawyers do. Yeah. Yeah, they're going to defend the bank or the computer. I mean, there's some noise starting to come. My idea was to take them at 2:50, and then maybe we're a little bit behind because I really wanted us to start the piano at 3, but so. Do you think if I get them until 3? Yeah. Okay. Can I see a show of hands if you need more time? Okay, we'll give you a little bit more time. talking. That's good. Okay, this is a good sign. They're doing it. How many people still need more time? Doing good? Okay, couple. Okay, I'm going to see if we have some groups that are ready. Can you raise your hand if your group is ready? Any groups that are done, completed? No. They're working. Okay, they're working. Okay, any groups complete now? Any groups, have they gone through all 5 questions? We're going to give you just 3 more minutes and then we're going to go ahead and start so we make sure we have time to do some of the panel questions. Yes. 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 If you, yeah, yeah, you guys. Yes. 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 Do you want to? There's 5. There's 5 questions. Yeah. 5 groups. Yeah. I think we just, I think if you, we have each of you stand with a microphone on each side, we can maybe all ask for one and who raises their hand. Yes. Yes. They will not speak. Okay. Sure, that works. Get microphones. I think they're okay. I think they're okay. We'll take whatever they have. Okay, I have one more minute, and then we're going to hear from you. Just we'll find a group who wants to answer one. If you want to, you think you need to assign it. You don't think anybody will volunteer to answer it.
Yes, let's.
So you could just start here. One. You can start with the first group.
Yes.
Yes.
One.
Yeah. Sure. Okay. They're gonna. They don't.
She's in. Everyone.
Okay, all right. All right, okay. Oh, you know what? Cohort, I think we do have some volunteers. Francis, we do have some volunteers of people who would like to talk. So we'll let people talk who would like to. Yeah, Francis, we have some people who'd like to volunteer.
We're all very glad to be to do this co-mediation, and we're grateful that you've chosen us to mediate this matter between Computech and Golden State Savings and Loan. Just to get us started, I wanted you to know that you're both very important organizations in this state, and I just want you to know that whatever we decide or discuss will not go outside the four walls of this room. I'm also aware that your relationship has just commenced, and it's going to be for almost a decade. So I congratulate you on that accomplishment. I also want to say that you will be in charge of how this matter ends. And so I'd like us to regard it as an opportunity, even as we reflect on some of the things that have upset us. I just want you to know that there's still a chance to solve this amicably. What we're going to do is we're going to use the first half of the day to talk about the problem and the different interpretations you had of the contract. And then after lunch, we shall go into the numbers and understand who pays what. And so I don't want you to worry about that. Let's first work on the problem and find out exactly what each of you think. Please remember that the most important thing is that you are heard, and I'm here to make sure that you express yourselves fully and that there's no misunderstanding for when we meet after lunch. We've prepared a beautiful meal for you, and I hope we enjoy that and I'm sure it's going to be better than what you had in the Bahamas. Okay, so now I'm going on to the validation.
Okay, well, I'm
Maybe
going to have you
before-
pause. We'll just have you answer that one. First of all, beautiful that you actually did an opening statement. That was much harder than I expected. I just expected you to tell me. So the fact that you took it on and engaged and did an opening was beautiful. A lot of safety and hope in that opening statement that they could actually resolve it. And you did a beautiful thing of customizing and leveraging that 10-year relationship they had, which was beautiful. There was also a lot of other priming in there about how they were going to behave. I loved that you framed it, that they weren't going to talk numbers until after lunch. So you created that expectation. So beautiful job.
Thank you.
Yes.
And we
Yes,
just
so
wanted to continue with the number 2.
You know what, we're gonna, thank you, but we're gonna move on to another group just so we give, because we really just have time for each group to answer one of the questions, but thank you.
Perfect.
So this group will have a go at number 2.
So number 2 was how to validate Computex feelings.
Thank you very much, our mediator, for the opening. We feel safe in this room. To validate the feelings of Computech, part of the aspects that come out of the facts is that the amount of money that has been spent is something that is an industry practice that is known to be incurred and expended by the client. So there's a sense of unfairness on part of Computech if such a cost is not accepted. But more importantly, a sense of injustice, knowing that these are costs that are incurred in the course of installing such technology. And the training is known globally. So there's a sense of injustice and unfairness, and partly betrayal on part of Computech if the cost is not taken care of. Thank you.
Beautiful, great job. So a sense of being treated unfairly and having an injustice put on them, and also betrayal, that they betrayed this contract that they have and not treated fairly under it. Beautiful job. Can someone else talk about, for Golden State, what feelings do you think you're going to have to validate in that caucus room?
And we have someone from here to talk about feelings as well. Balancing.
Thank you very much, Professor, and thank you very much, Francis. Our group discussed and we felt that the feelings for the bank, which needs to be validated, is that they are going to be very much disappointed that they have to pay for this money to this other company, yet they don't pay their own staff this particular payment. So that would be a very big disappointment, which will be the first one. The second one is where the training took place. They would feel it is unnecessarily expensive because of the place, and they wouldn't offer it to any other people. So those are two feelings that you have to validate for the bank. Thank you.
Yeah, the disappointment and then a feeling of maybe being taken advantage of. This was unnecessary for them to go to the Bahamas. Great. Could someone then give me the version of the story that you're going to have to show you understand for Computech? Over here? Great. Yeah, go ahead.
Thank you. In addition, just adding on to the validation for Golden State, we think this was a luxury. The fact that they chose to go out and have it in the yard. It was also outside our bank policy, and we think it's a cost that we may not be able to stand by, and it was not provided for in the contract. Thank you.
Thank you. Well, that actually sounds very good, like facts. That sounds like you're validating the facts, their version of the story. Good, good.
So, Prof, do we move to the next question?
Yes, although I have someone handed the microphone here. Is there? No, okay. Okay, yeah. The next question, the final question is for Computech. Can somebody do the validating or understanding the perspective of Computech?
Okay, we'll have a volunteer here. Have a go at that.
Okay, so for Computech, the version of facts that show we understand them is they have a reputation to protect with their clients. They want every other client to be able to pay for this training, and they can't just excuse the bank and be that one client that gets the excuse. And then they feel that this training will benefit the bank because it's going to help it will help them deliver better service to the bank, which will then help them deliver better service to their clients. And then the other thing is that it's industry practice, so it's nothing new. They feel that they're entitled to this, and in addition to that, the law recognizes this right.
Beautiful job. That was a beautiful, thorough job.
Just to supplement about the yacht,
Yes.
they are giving the best in class in that training that is only available in those circumstances. And you can't give less to a client that you hold dear.
It's like the best dispute resolution program in the world is in Malibu, right? It's the same thing. You have to go. Yes, great. Oh, excellent job. Give yourself a round of applause. That was fabulous. Really good. I hope that sticks with you for when you're in a mediation to think about just going through those simple steps and pausing on that. So amazing. So I would like to ask the cohort now to come back up on stage because we're going to try and address the questions that you submitted, some of you submitted when you registered. And the cohort, as I said, has taken great care in thinking through. They all wrote out responses to the various questions, and we're now going to spend some time answering them. I want to, though, while they're coming up, do I see them? Are they coming? Are they moving up? Come on up, cohort. While they're coming up, I wanted to share something with you that's pretty special. You saw a picture this morning that I put on the screen of the founder of Mediators Beyond Borders. And Ken Cloak is a dear friend and just an amazing mediator and thinker. And he's written, as I said, 12 books already on conflict. And he's actually quite ill. But the last book that he is finishing up is a book that's called The Magic in Mediation. And when I told him that I was coming here, and I actually was talking on that subject, he shared with me the first chapter of that book that I will put on the conference site. But I just want to share some of his beautiful words about it as we kind of leave and close up the idea of the magic of mediation. He first starts with a quote by Yeats. He says, "The world is full of magic things, patiently waiting for our senses to grow sharper. Anyone who has mediated even a few disputes is likely to have experienced the magic of mediation and would very much like to do so again. But if asked where this magic came from, how it happened, what it consisted of, and how they might replicate it, most would be hard-pressed to answer. By magic, I mean something inexact, probabilistic, meaningful, even poetic. Something with hidden variables, something so sensitively dependent on changing condition that it can quickly turn chaotic, unpredictable, and irreplicable. However we define magic, it requires a mixture of just the right ingredients in just the right way at just the right time, in just the right circumstances with just the right people, and it can disappear without warning when these are not exactly in the right ratio. In mediation, ingredients are subtle, complex, hidden, camouflaged, denied, multidimensional, intensely emotional, and normally constantly changing, so that the very same techniques that result in agreement at one moment may end in impasse at another only moments later. A single word or gesture, if handled correctly, can lead to a breakthrough, and if not, can trigger aggression, aggravate tensions, prompt denial, and end in intractability. For this reason, nothing in conflict resolution works always, everywhere, or for everyone. And also for this reason, everything in mediation is imbued with magical possibilities. What we therefore need to do is figure out what it consists of, where it comes from, how to release it, and gradually get better at finding, feeding, and fermenting it. So I want to just leave you with that thought on the magic of mediation. This process is so important. It doesn't work every single time, but your job is to set up the process so it has the best chance of happening. So with that now, I'd like to turn to the panel and have them share with you their responses to some of the questions. And we'll start out talking about the current state of ADR in Uganda. And I will ask Justice Kaye to respond to this question. How is ADR being administered currently in Uganda? And can a judicial officer combine mediation with adjudication in the same matter? And what steps are in place to make mediation legally binding?
Okay, thank you, Professor. I kind of believe when I went through this that a lot of this was covered yesterday in terms of the legal framework. I don't know if that's really what you want me to say, but we went through the legal framework right from the Constitution, the mandate given to the courts under Article 126, especially in terms of speedy trial, ensuring reconciliation, and avoiding technicalities in favor of substantive justice. I think we covered a lot of that. But in terms of administration, I think I want to put it into two categories for us to think through. That going forward, I think we should recognize that there is that which is administered privately and that is administered through the courts. And right now, currently, we are seeing a lot of activity in the courts because that is court-annexed ADR, court-annexed or court-connected ADR. And I think with the combination of the 2013 rules and the 2019 rules, civil procedure rules, you are able to go into the courts and seek a diversion to alternative dispute resolution. And the main driver there will be Order 12 of the civil procedure rules. That is largely on the civil side. We shall talk about criminal, but also we have seen the growth of private administration. I don't know if we can call CADA really private. It is it's a little bit of a hybrid because it is set up under the Arbitration and Conciliation Act and is supposed to get a significant part of its funding out of out of government. But CADA has been around slightly longer than 2000, and it also has a panel of mediators. It is an appointing authority as well. And I think quite a number of the early court-annexed mediations took place through CADA. Now we have ICAMIC, which has come up, driven by a purely private effort of the bankers and Uganda Law Society. I think we had a talk about them, so that is another area that is happening. But also we are seeing other efforts, the Praxis Conflict Center, and just this afternoon, practice to alternative dispute resolution in the West area. So, Minister, that there's going to be, as a result of the national ADR policy, there's going to be streamlining of a lot of these private efforts, and in terms of recognition, licensing, and things like that. So I would like really for us to debunk that, because that has been the main effort, that administration is largely either court-connected or court-annexed. I think we have now seen the growth of private efforts. So that is what is happening. There has been issues raised about legally binding. How do we get ADR to be legally binding? Especially this question was in the area of mediation. And I think you must now be aware of in the 2007 rules and the 2013 rules, mediation rules, 207 for the commercial court and 2013, which are more of a general nature, that it is possible, like for example, in the 2013 under Rule 16, to have the consent agreement taken to the officer responsible for mediation in the court system and have that converted into a consent judgment. Now, this is a very significant tool to make the mediation legally binding. In many mediation laws in other parts of Africa, this capacity to convert the agreement into a consent judgment is not there. So I think we have a very good possibility of doing that within Uganda. Now, the question referred to mediation, but I also want to remind you that there is conciliation under the Arbitration and Conciliation Act, and it is possible to get the conciliation agreement also endorsed in the very same way as it would be an arbitration award to become a decision of the court. So you have this flexibility which is ingrained into the legal framework that allows for enforceability, and it is critical to deal with some of the literature that says that you can only get it legally binding if you enter into some agreement which can only be enforced as a contract. So in Uganda, we have a higher level of interface in that regard. I think I'll stop there. Thank you.
Justice Kate, could I get some clarification? Is there anything right now if parties did a mediation agreement that was pre-suit, so there's not a case in the court, are they also able to take it and get it turned into a consent judgment?
The only one that can be done in that way is if you operate through conciliation under the Arbitration and Conciliation Act. So a private mediation would have to have the same qualities as they would have anywhere in the world, that it is enforced on a matter of good faith and as a contract, and it would be regarded as a form of estoppel by record.
Okay, thank you, Justice. Then moving on, we had a couple questions about acceptance of ADR in Uganda. And the first one, I'm actually going to direct both of them to Senior Counsel Francis. But the first one is, how do we deepen engagement, acceptability, and widespread use of ADR?
Thanks. In terms of deepening engagement, I think a lot has been said. That I was very, very pleased to know that in terms of this summit, it's been unique in many ways, because you have judicial officers, you have practitioners, you have users coming together to discuss ADR, as opposed to each one speaking to themselves in their own house. I think we need more of this. We need more of these sheds that interest the various sectors across the society to participate in ADR. So deepening engagement will require us to do more of this, to talk about the advantages, to preach about ADR and the benefits that it offers parties in effective resolution of disputes. But also, we also need to increase public awareness. I think when you hear people taking the law into their hands, it reminds me of what you are teaching about the mindset of a conflict. You are clogged, so as a result of stress, you decide to take the law into your hands. So we also need to engage wherever we are, us who have now become disciples of ADR. Wherever we are, we need to preach the potential of ADR in helping even the smallest unit of society, such as a family, to effectively resolve the conflicts that are in the families. Because there are so many conflicts. Many of them don't even reach the courts of law. You know, only 5% of the disputes come to court. 95 are resolved out of the court. So we are reaching out to where these disputes are and sharing skills on how to encourage them to resolve these disputes even much better. In terms of acceptability, this is a very important conversation that we should have, you know, as lawyers, because in many circles, there is a thought process that this thing called mediation is out there to kill legal practice business, isn't it? That fear remains in our community. Many will write off ADR and in fact treat it as something being innovated, you know, to stifle legal practice. I think to those who think like that, we need to explain to them that in fact when you talk about ADR, you are having a conversation with 95% of the people who don't bring disputes for litigation. So in fact, in terms of expanding the pie, the opportunities are even much more in ADR than elsewhere. And that is one of the reasons why when we had a discussion with Bankers Association when I was still president, the issue of arbitration was a very big issue. We did some study and found that actually we are less than 20 advocates who were members of SIAB. You can imagine less than 20 in 2017 when this conversation on just arbitration was picking up. You would also want to know that other professions had more than 20 advocates, more than 20 members who were SIAB members, and that was disturbing. In arbitration, what that means that effectively you have locked yourselves from the global opportunities that arbitration gives you. Because when you're a member of SIAB, or if you go and become a chartered arbitrator, you are able to be listed on a panel in many places because that is a recognized qualification. So you can imagine in terms of opportunities for you, you then stop thinking about only Uganda, you become international by just having that qualification. So that would then provide immense opportunities to the lawyers here. So in terms of acceptability, we just have to open our minds and understand that this thing is very important. There's something in for us and that we can make it work. Also, in terms of acceptability, we have to move towards an understanding that it helps resolve disputes better. At the end of the day, we work in a very limited space. Uganda is a small country. You can drive literally from Tororo to Arua in one day. The next day you can go to Kabaale and you have covered the entire country. So in terms of making our communities more cohesive, in terms of contributing to better resolution of disputes, ADR then must cease to be only, litigation must cease to be only a money-making tool. We must look at ADR because of the potential it offers society to resolve disputes better. I think that argument we should never forget, that in as much as we want, we also have a responsibility to give to society. And ADR gives us a mechanism to help people resolve disputes better and retain critical relationships, at least as far as mediation is concerned. Then lastly, the mediation mindset must also, for those who are in organizations, it's just not only disputes that are ready to be litigated, but also just your leaders having a mediation mindset is a call to listen to people more, is a call to invite people to be respectful more to the people you lead. It is a call to be more empathetic as far as leadership is concerned. So just adopting the mediator mindset gives you opportunities to even be a better leader in your bank or in any other organization that you represent. So I think there are things we can do to deepen engagement. There are things that we can do to increase on acceptability. But at the end of the day, we must be persuaded that ADR is no longer an exception, but we must make it a general rule to help our society. Thank you.
Thank you, Francis. Cohort, I'm going to skip around a little bit because I was told that the other group's going to be coming in the next 10 minutes. So I want to get to a couple other topics. This one I direct to Madam Rachel. This was a question that was asked regarding criminal cases and ADR, and it says, should the court foster reconciliation and compensation at the stage of sentencing, and should reconciliation between family of accused and the family of the victim have a bearing on the sentence?
At the end of the day, the court is always looking to not only to adjudicate and come up with a decision, but to foster reconciliation. When we look at Article 126 2D of the Constitution, one of the responsibilities is to foster that reconciliation between the parties. So whatever stage it is and whatever decision the court is taking, it's important that reconciliation is also part of it. So when you look at a criminal trial, you are first of all dealing with an offense against society. So you would adjudicate, you'd listen to the facts and you come to a decision whether you convict or you acquit. And even if you've acquitted somebody and you're passing sentence, there is no harm in looking towards some form of reconciliation. Whether the person serves a sentence or not, there is a victim of the crime. And the victim of the crime is not looking only for a sentence. They're looking for some kind of an acknowledgement of the crime that has been committed against them. And they need to receive some form of satisfaction for there to be any type of healing. Ultimately, this accused person is probably going to come back to the community. They'll have to be reconciled with the community even after they have served their sentence. So the earlier we can start the processes of fostering the reconciliation, the better. So if within the process of determining the matter and sentencing the accused, we can also incorporate some aspects of peace building and healing within that sentence, whether it's through compensation, whether it's through some kind of an acknowledgement or an apology, then it goes a great way, not only in addressing the grievance that has been done against this individual, but also in bringing the entire society, the entire community together to close that particular matter. We do that both when we go through a full trial, but also when you go through the plea bargaining process. When you go through the plea bargaining process, there's an opportunity for the victims, for the complainants, to also have a say in the process and to have an opportunity to express themselves about what they think is the most appropriate sentence. And at the end of the day, what the court is looking for is resolution for the state and for all the other parties involved. And reconciliation is a big part of that. We've seen instances, for example, where even before someone has served the sentence, they have already reconciled and they've already come to peace with each other through whatever other means. And the state can go ahead to sentence this accused person, but there's already a process of healing that's taking place. So eventually, when this person has served their time and paid their dues, they can comfortably come back to the society and life can pick up from there. It's particularly important where the accused and the complainants are people who are familiar with each other, family members, community members, because there's more than just the crime. There is a deeper relationship, and that healing has to come, and there's a responsibility on the courts and on the state to foster that healing. So it's important for us, even when we're handling the sentencing, to look towards some form of reconciliation.
Thank you, Madam Rachel. I'm going to skip down to a question for the minister, and this was concerning the new ADR policy and the AJS strategy. And the question is, what is the actual action plan for the implementation of the ADR policy and the AJS policy?
The purpose of the ADR policy is to declare the policy of the government to fully support ADR. And while leafing through my notes here, the purpose of this conference, the summit on ADR, is because we find that a more conciliatory approach to dispute resolution will unclog the judicial system, because then parties don't have to litigate. Alternative to litigation, we are not seeing it as an alternative to maybe what we call the common law or Western judicial system. So it is a renewed emphasis on conciliatory approaches to dispute resolution. From here, we shall be having an in-house meeting at the Ministry of Justice. By the way, the government is the most sued organization. Everybody sues the government, whether they have a case or not. So we have, as of last month, close to 3,000 civil cases that are gathering dust. We have decided to introduce an electronic document archiving system. That way we will be able to look at each case and evaluate which ones should be submitted to ADR. So without even having a conversation with the judges, we are already a party at the Ministry of Justice. So that is where we are going to take the knowledge we have got from here. And the Solicitor General is here. After the meeting with the Ministry of Justice practitioners and all the people of the Attorney General's chambers, which is really the government law firm with the Attorney General as the managing partner. Now, my job at the Ministry of Justice is to lead the politics and the policy. After that, I'll be appointing the National Alternative Dispute Resolution Advisory Committee because, like I said in the consultations, to build a tall tower, you need scaffolding. Now, the scaffolding is not part of the building, but without it, you cannot build. If you look across the street, those of you who walked out, there's a tall building coming up. There are people standing on metals, there's the crane. So we need all those to build the ADR structure in Uganda. And at the heart of the scaffolding will be the National ADR Advisory Committee, which will be supporting the committee that the Deputy Chief Justice has been steering. But that is going to be to push us. You know, government is like a donkey. It works best when some force is applied in its rear end.
And on that, those words of wisdom.
A kick in the butt.
Thank you, Minister.
Lastly, will now be the cabinet decision. You have got the assurance from none other than the President of Uganda. So, in case you were fearing any resistance from the executive branch, I think the President has assured all of us that ADR is now going to be the new operating system to support the hardware of our justice system. Now, the policy will be launched, and then we go into dissemination. And the dissemination will be through the Judicial Studies Institute, which is fairly well established. The Uganda Law Society will be on board to disseminate. And finally, my selfish interest in supporting this summit was because I've been having applications for accreditation. People want me to issue instruments for them to start training and accrediting arbitrators. And on my desk, there was no formula. I didn't know how to proceed. So I called a few friends, namely Professor Andrew. I called Francis Gimara. I started speaking to the Solicitor General. The Pepperdine team came and we had a very long meeting together with the Attorney General. So we basically refused to issue any instrument appointing anybody to accredit ADR practitioners. I was at the risk of being misunderstood as an opponent of ADR. So this summit has also saved me. And I believe that in the next month of July, I'll now be more open to issuing some instruments, particularly for those who want to do mediation. So this is the way forward from where I'm sitting. Let me also thank the veteran justices who came here and gave us very good feedback. And we take this feedback back to our offices. We also take it back to our class because we are still students. So in a way, we have rigged, we have cheated in the exams because we have consulted outsiders.
Yes. Thank you so much, Minister. People are starting to come in, but I don't want to leave the Solicitor General out. And I looked at the questions you were assigned, and the one I don't think that we've really answered at this conference, that knowing the good student you are, is where has ADR best worked in Africa? And I know he did research on this, so let's hear his research.
I didn't, because you gave me 5 questions, so I don't know which one you want.
So I'm just giving you that one. I picked one for everybody. So yours is, where has ADR worked best in Africa?
Okay, thank you very much. According to the results of the survey by the School of Oriental and African Studies published in 2020, the best rated countries are Nigeria, South Africa, and Egypt. And the institutions under which they operate are the Arbitration Foundation of South Africa, AFSA, Cairo Regional Center for International Arbitration, International Commercial Arbitration, that is CRCICA, and the Lagos Court of Arbitration. Those are the best rated institutions as far as the School of Oriental and African Studies is concerned. And this survey was done in 2020. And I think this is the best time that we have come in. And I thank the Honorable Minister and my Lord, the Deputy Chief Justice, for bringing this on board, because now we are looking forward to competing, to being one of the best. It is a best seats for arbitration. And when you look at what attracts arbitration, Professor Jim Gash talked about it, a number of senior people have talked about it, is to make it the legislation that we enact. I've looked at the Arbitration and Conciliation Act. There are a number of very good provisions in there, and Justice Kirabu will talk about it, even conciliation. Conciliation is also, as provided in there, it is a process that is structured in such a way that at the end of the settlement, the conciliator does prepare a settlement that is filed in court. And once it is filed in court, the coercive force of the court makes it enforceable. And of course, yesterday a number of people talked about the courts being supportive of the ADR. Justice Mubiro talked about it and said, if you try to cheat the process, instead of giving you a grace period of 90 days, they will give you 30 days. So I think it was a warning to people who are pro-litigation that the time has changed and we should embrace ADR as the next method of solving disputes to save time, to save our clients from having to to go with the lawyers when they want to create jurisprudence. They are not interested in jurisprudence. So these are the best centers, and we hoped we shall reach there also. Where there's a will, there is a way. So this is just the beginning, a stepping stone, the building blocks. But we shall go there. With all your support, with the support of Pepperdine, I think, like Muslims say, inshallah, we shall be there. Thank you.
Thank you. Great words to end it with, Francis. Well, I want to thank my distinguished panel of cohorts. They were great teachers. This definitely was a mediation effort to put this on, and it has been a joy and a pleasure to work with all of them. And thank you to all of you for your presence today and your engagement. So give yourself a round of applause. Thank you. Did you see a treat?
Yes. I've seen it. You can imagine the excitement.
I love that you get so excited.
Great efforts by great men and women in the house. Great efforts indeed. Let's appreciate them once again. We are right now waiting for track 1 that was meeting in Choga Hall to also come and join us, and we continue with this auspicious occasion. I would like to give you good news that we are now at the beginning of the end of this very important National Alternative Dispute Resolution Summit 2023. The plane has been in the air, starting to get down because it's about to land. So keep your belts tightened very well, because the two most important parts of the flight is when it is taking off and when it is about to land. So tighten the belt. The plane is about to land, ladies and gentlemen. When track 1 enters in here, the team of the judges, we will have some bit of a debrief concerning a few lessons learned from the two tracks, from the track of the judges, but also from the track of the practitioners and the users. And once we have had a debrief of the lessons learned, we will get to launch the summit website, and we will be giving you important information that you need to be able to navigate through the whole summit website, and how you will be able to access a lot of important pieces of information. And then thereafter, we will launch the Alternative Justice System Strategy for the Judiciary of Uganda, June 2023, which is ready. It will be launched in the next couple of minutes. Once that is done, we will have the closing remarks by the DCJ, the Deputy Chief Justice, Honorable Justice Richard Butera, and thereafter, we will hand out the certificates and the conference booklet, and we will call it an ADR Summit 2023. Definitely, you see, we are almost done. So I would like you to not be tired, but instead to be rejuvenated and inspired, to turn to your neighbor and say, the plane is landing, the plane is landing. Tell your neighbor, the plane is landing. The plane is landing. So keep in good mood, keep inspired and ready, the plane is landing. But just like I said a few minutes ago, the two most important parts or moments of the flight is when you are doing the takeoff and also when you are doing the landing. Those moments, you must ensure that your belt is well tightened. All right. So at this moment, I'm going to allow us have a very simple, small energizer as we wait for track 1 to get in, because they are aware that here we are done. So I'm going to request us to get on our feet. Only those who don't mind. In case you mind, it's okay. You can just feel free. Just keep seated. Yeah, you don't have to be troubled by these things. In case maybe you're tired, maybe it's okay to keep seated. But in case you would like to join in this simple energizer, then feel free to get on your feet. And when you keep seated, and then you see the energizer is enjoyable, don't join us. Keep seated. Because you have already made up your mind. All right. So ADR, it brings together all people. The young, the old, the ladies, the gentlemen, rich and poor, black and brown, and any other color. All of us. And among those people that are practitioners are the old men. And I would like to pick on one of them and call him the old man of ADR. That man has just come to town this morning. You know, and he is here with us, and I want us to welcome him. So just say, the old man of ADR has just come to town. Now, you better listen carefully to what I'm about to say. The old man of ADR has just come to town. He came with his wife. His wife came with their son. The son came pulling the dog. And the dog had a tail. And on the tail, there was a tick. The old man came with what? Friends, do we need a mediator on this? Okay, let's do it again. The old man came with the wife came with the son came with the dog had a tail, and on the tail there was a tick. Now, I am a trainer of public speaking. At Inspired Leaders International, we have a certificate in public speaking and presentation mastery. We are having the 37th intake in August. One of the things we emphasize about is the non-verbal communication. You may just say words, but if you don't attach the facial expression, the hands, the gestures, the body movement, the posture, etc., your communication will not be impactful. Now, help me to decide on the non-verbal. When we say old man, how can we show old man using our body? Let me take that. So let's say the old man of ADR has just come to town. So we are assuming we are holding a stick, a walking stick for the old man, right? He came with the wife. So how do we demonstrate a wife or a woman? Oh, I see many ideas. Like holding. Let me take that one. But that's quite hilarious. But let me take it. Okay, so somebody has demonstrated using, part of the body. So I will take that for him. So, yes, you get it. We are together, right? So let's begin. The old man came with, all right. And they came with the son. How do we do non-verbal communication for the son? Oh, I see SG doing this. Let's take that. So, like a young man, right? Okay, so we start. The old man came with the wife, who came with the son. Now the son had the dog. So what do we do with the dog? Non-verbal. The body. Okay. Somebody is suggesting the body of the dog. Okay, so let's take that. All right, it's okay. So, the body of the dog. So let's go. The old man came with the wife, who came with the son, who had the dog. Now, the dog had. So how do we? All right. Oh, okay. Let's do that. The DCJ has given us this one. So let's do that one, all right? This one is the tail. So we are back. The old man came with the wife, who came with a son having their dog that had a tail. All right. And on the tail there was a tick. Tick. Cancel. I don't think we are talking about this tick. Oh yes. Honorable Justice, yes. Let's take that. So like you are holding the tick. All right. So let's see whether we have it. We go, the old man came with a wife who had the son pulling their dog that had a tail on which there was a tick. We are really doing well. So this is the simple song. The old man of ADR has just come to town. The old man of ADR has just come to town. So let's see whether we got that. 1, 2, let's go. The old man of ADR has just come to town. The old man of ADR has just come to town. Now remember he came with. So now it will be the wife of the old man of ADR has just come to town. The wife of the old man of ADR has just come to town. So now you can imagine where we are going with this. Good to go? Good to go, ladies and gentlemen? Kindly raise your voice as you sing that and demonstrate non-verbal for impactful communication. Good to go. 1, 2, 3, let's go. The old man of ADR has just come to town. The old man of ADR has just come to town. The wife of the old man of, where are you? Has just come to town. The wife of the old man of ADR has just come to town. The son of the wife of the old man of ADR has just come to town. The son of the wife of the old man of ADR just come to town. The dog of the son of the wife of the old man of ADR has just come to town. The dog of the son of the wife of the old man of ADR has just come to town. The tail of the dog of the son of the wife of the old man of ADR has just come to town. The tail of the dog of the son of the wife of the old man of ADR has just come to town. The tick on the tail of the dog of the son of the wife of the old man of ADR has just come to town. The tick on the tail of the dog of the son of the wife of the old man of ADR has just come to town. Ladies and gentlemen, please take your seats. I didn't know that people speak in tongues. The dog of the son, of the tick, of the old man, of the wife. Jumbled up. We needed an arbitrator. I think as we wait for track 1 to come in, we could right now get to the website. So I don't know whether, Aziz, are you able to project so that as I talk about it, the friends in the room are able to see what we are talking about? Yeah, the old man has come. Okay. Just waiting for it to be projected, then I can show us what we are able to do with it. This website has been developed by one of the people in the room, a lawyer by the names of Chitaka Aziz, and we are glad for his wonderful technical abilities. Okay. Aziz, do I wait or I continue to talk about it? Oh, great. So that's the website. The first high-level national summit on alternative dispute resolution 2023. So you see it has the side of about the summit. It has the summit program followed by the speakers and then followed by the Summit Resource Center. There is going to be an addition of the 5th tab that will also be giving you more resources. Now, all the presentations are going to be under the Resource Center. So when you click On the resource center, under that menu button, a number of resources are going to be coming. You can access the different papers as you can see them, the different communications that have been given. You can also access the pictures of day 1 and also the pictures of day 2 on this very important website. So now you see it's taking us to the side of the pictures. The communication by the president is there. You can either read it or you can watch it. It's in 2 formats. The same thing with the message of the CJ. You can either read or watch. Then you'll have the one of the minister right there. Okay, the full details of the program. Then the different speakers and their different profiles. You will be able to find them there. The whole summit schedule as it has been, you will be able to follow how things went. Now, coming down, that is where we have the photos or the pictures. So we have photos for day 1. If you click there, you will see many of them. So you may want to go check there if you want to be sure, based on the relationship you have with your wife, you want to provide evidence. This is where you access the evidence. It has not been confiscated, okay? You can go and pick a photo of yours and say, behold, my darling, I was there. That's where I had gone. And then you will see the video of the whole day 1 down there. And then below, there will be day 2. We are still on day 2, so they are putting together all the pictures and putting them there, and all that is happening right now is there. So you can access full day recordings for day 1 and day 2, and all the profiles for the speakers, and all the remarks, as I have already showed you the different things. So all the information about the summit sponsors, as you can see, the partners, the co-hosts, all that information is there. There is one other feature whereby you are able to send your feedback about the summit on this very website. Aziz, are we able to see the feedback side? Okay, he's looking for it. So you'll be able to send your feedback about the summit. You can also send your suggestions on the website, through that portal of the feedback. And lastly, you can view the summarized key quotes about the speaker points on the summit, on the Twitter handle, First High Level ADR Summit. That's where you can find all that. So make sure that you go to it. There were some QR codes, the pieces of papers that were on your tables yesterday. The moment you scan them, they can take you directly to this website and be able to navigate the whole website. I think Aziz did a great work, the fellow lawyer in the house. Let's appreciate him. Please come, let's know. He's not big he's as big as I am. Many times when I send my profile somewhere, I'm going to speak, maybe keynote at a conference or summit, and people see the name, they think the man is 72, and he's big and tall. Then when I surface up and I say, let's welcome the keynote speaker, and sometimes you see people in the audience looking at me like this because they expect somebody bigger, taller. So Aziz has done a great thing. I think you were expecting somebody bigger and taller. This is a great man. Big things come in small packages. So thank you very much, Aziz, for the great work done. Do you accept business to do this for other people who want? You do. Don't forget my commission. I hope there will not be a need for litigation against me. Now, ladies and gentlemen, today we are also going to be launching the Alternative Justice System Strategy for the Judiciary of Uganda. It's my pleasure to let you know that this is not only happening in Uganda. Right now, as I say this, DCJ, or all the lords and ladies and gentlemen in the house, as we talk right now, there is the second national conference on alternative justice systems in Kenya that is going on right now. It also started yesterday, the 26th of June, and it is ending tomorrow. And most of the efforts that we have here in developing our alternative justice system strategy, we've been also been supported by the AJ Systems Committee in Kenya under Justice Joel Ngugi. Right now they are congregated at Tangaza University College. So this is something that is happening across the region, and I believe that we are doing something very timely as the judiciary of Uganda. I think we should celebrate that with a round of applause and urinations. Yeah, yeah. Other people will be playing catch up following us. Now, I'm going to request the DJ to give us one small song, an interlude, and then I will be telling you what next in the next about 3 minutes only. Enjoy the little break.
all the deliberations that have taken place. We want to thank you for the health, for the feeding, for the wisdom and knowledge. Your word says, King of Kings, that knowing you, wisdom comes from knowing you. We want to thank you for being the foundation and the base of this discussion, being the maker of peace. We ask you, Jehovah Shalom, that whatever we've learned will be wisdom to us, will be implemented, will be drawn down to the communities, and will reveal your power of reconciliation. We thank you for all the people that have participated in this and all those that have imparted wisdom on us. May your glory be seen in all this, and we pray all this in the name of Jesus Christ our Lord. Amen.
Thank you very much. We appreciate. And ladies and gentlemen, that marks the end of the first ever high-level Alternative Dispute Resolution Summit 2023 in Uganda. As we move out, the facilitators and the moderators come close to the Minister of Justice. He will be giving you your certificates. I stay Samuel A. Bakutana, Certified Executive Coach, award-winning leadership consultant, global speaker and author, the CEO of Inspired Leaders International, the husband of Charity, the father of two, and the national president of the Fathers Union in Uganda. God bless you all. God bless Uganda. God bless the judiciary of Uganda, for God and my country. So facilitators, make it to the front to get your certificates. Facilitators and moderators, come to the front, and the minister will be giving you your certificates.